All right, let's get started. All right, this is the time and the place for the hearing of case number FDA 22-01 involving Julian Walker, the appellate, and Mapleton School District. I am Cameron Pope, panel chair. The other panel members are Dwayne Johnson and John Hartsock. We've been selected from the Fair Dismissal Appeals Board to hear this case. Legal counsel for the panel is Jonathan Grew, Assistant Attorney General. Our court reporter today is Ryan Batterson, and the appellate is Pro Se. The school district is represented by Nancy Hungerford. The time is 8:18 a.m. and the date is July 13th, 2022. The hearing is being held at Lane County Educational Service District. The appellate in this case has requested a public hearing. To accommodate this request, the hearing shall be live streamed through the internet with the link posted on the FDAB website. The panel operates under administrative rules that are available for the parties online at the Secretary of State's website. Do the parties waive their right to review of their rights under a contested case proceeding?
I'm not sure what that means.
Yeah, and I anticipated that in a prior email, I think you indicated a desire to have the rights provided.
Mm-hmm.
So I will read them out, especially since you are pro se. And this is for both parties. The rights of the parties, these are found described in OER 586-030-0060 and OER 586-030-0044. First, all witnesses shall be heard only upon oath or affirmation. And I'm going to describe the hearing process for you. There'll be an opening. The district will make an opening statement. Then the appellant makes an opening statement. Unless the appellant wishes to reserve the opening for the beginning of the appellant's case in chief. The district's case in chief, the district will present evidence in support of the district's case. The witnesses called and directly examined by district are cross-examined by the appellant after that. Redirect and recross may occur as needed. For the appellant's case in chief, the appellant can present evidence in support of the appellant's case or rebutting the district's case. Witnesses called and directly examined by the appellant are cross-examined by the district, and then redirect and recross may occur as needed. The panel may ask questions of any witness. Also, there is rebuttal and surrebuttal. The district may present rebuttal evidence at the close and of the appellant's case, and the appellant may then present surrebuttal evidence as well. Since the appellant is pro se during the course of the proceeding, the appellant may request a recess if the appellant determines representation by an attorney is necessary to protect the appellant's rights. An opportunity for adjournment exists at the end of the hearing if the parties determine that additional evidence should be brought to the attention of the panel. In this case, the record will be kept open for 14 days to determine if additional evidence is necessary. After the hearing is closed and the record closed, the panel shall deliberate and then prepare a written report in the form of a final order. Party may file a petition for reconsideration within 21 days after the order is served. Party opposing the petition has 14 days to submit written objections. If the panel does not respond within 60 days, the petition is considered dismissed. Party may appeal a final order by filing a petition in the Court of Appeals within 60 days from the date of service of the final order. For the kinds of evidence admissible and objections allowed in the burden of proof, I want to explain that. The evidence standard is a type commonly relied upon by reasonably prudent persons in the conduct of their serious affairs. Objections must be made at the time of evidence is offered or it is waived. All offered evidence not objected to will be received. However, the panel can exclude irrelevant, immaterial, or unduly repetitious evidence matters. The FDAB might receive evidence conditionally and rule on the admissibility of it later on after the hearing. The degree of proof of all of factual determinations will be based on the preponderance of evidence standard. I don't know if you want me to define that. I'm not going to try, but that's more likely than not. That's usually a very squishy definition. The burden of presenting evidence to support a fact rests on the proponent of the fact at all stages of the proceeding, at hearing and after hearing. The burden of proof rests with the party legally responsible to establish the particular fact. Privileges. The panel shall acknowledge privileges recognized by law when receiving evidence and ruling on objections. There's a special rule that's important. It says that this is OAR 586-030-00605. Parties, witnesses, and counsel shall conduct themselves in a respectful manner at all times and are subject to sanction up to summary dismissal of their claims for violation of this rule. We obviously don't anticipate that, but I think it's an important rule to put out there on the record. And that is the rights of the parties.
Okay. This hearing will be recorded by our court reporter. A gentle reminder to all parties that it is important that only one person at a time talk, so the reporter can accurately capture all portions of the hearing. The reporter will only prepare a transcript if requested to do so by the panel after completion of the hearing. If you want a copy of that transcript before it is ordered by the panel, please contact the FDAB executive secretary so that the necessary arrangements can be made. It is important that only one person speaks or testifies at a time for the purpose of a clear record. If more than one person is speaking, the court reporter will have to choose which speaker to include in the record. Please turn off your cell phones, pagers, or any other electronic device in which may disrupt this hearing. Okay. Do either of the parties need to take a break to discuss pre-hearing matters prior to the starting of this hearing?
No.
No, but I do have two questions. If I were to make an objection to an exhibit in order to not talk over someone else, when would be the appropriate time to do that?
I would say if you make an objection, I think people will generally stop
Okay,
and you may be asked grounds for objection. And then the district will have a chance to explain what they think of the objection. So I think people should be able to moderate.
okay.
Does that make sense?
Yeah, and then so if the exhibit is accepted by the panel, would that be, would they say like overruling the, what would be the phrase?
Oh, okay.
How would that be phrased?
So-
I know what to have.
If an objection is, if the panel disagrees with the objection, does not want to grant it, it will overrule the objection.
Okay.
Agrees that it will sustain.
Okay,
Wait, yeah, did I misphrase?
No, you're right.
You're right. Anyway, so yeah, that's pretty much how it would be phrased.
okay. And then my second question is, if I want to reserve my opening statement until I present my case, I'm letting you know that now, that I'm going to reserve my opening statement till when I present my case.
It's fine to let the panel know that now. It could also be after the district makes its opening. You could say we will reserve.
Okay,
That's fine too.
okay.
Okay. All right, so the parties stipulated the receipt of the following exhibits, which are received. So we have the exhibits. Is that correct?
Yes, so this would, in other words, are there any stipulations on the exhibits so that we don't have to?
But the district's we're not going to object to any of the exhibits. Because I think it will take out far more time than this panel has to date. But what we do indicate from the record here is, first of all, there's a lot of duplication between the two record books. We're going to be largely working off the district ones during our testimony. The second thing is that normally statutes and rules and so forth are not considered part of the record, but I'm not going to object to the ones, and we leave it up to the panel to decide what is relevant. You know, that's the major objection anyway, is lack of relevance, and in administrative hearings, relevance can be very broad. And so I don't believe that it's worth the time to go through an extensive review of some.
Yeah, I mean, I've already stated the objections that I made earlier regarding my understanding that, from my point of view, I believe that the evidence should be limited to what was presented in the 20-day termination notice. But that would apply to any evidence that was presented that wasn't presented in the 20-day notice or the termination notice. So I'm just going to kind of give broad objection. So we're not objecting to every single thing. Does that make sense?
An ongoing objection. That's what it's called. And
Okay. Yeah.
and that's or continuing objection.
Yeah.
So I think the panel takes note that it's a continuing objection.
Mhm.
District does not object to any of the exhibits.
Mhm.
And you have a continuing objection on any exhibits that were not in these personnel files. Is that
Yeah, things that were not in my personnel file at the date of the 20-day termination notice,
Okay,
March 9th.
okay.
So,
If I may be heard.
Mhm.
I do not find anything in the district's exhibits that is not also in the appellant's exhibits. Insofar as they're presenting them, they are part of the record. And I have not objected to their presentation.
We can move on.
Yep. Okay. All right, so we're going to move on to opening statements. Do the parties wish to make opening statements? We will start with the district.
I have a copy of my opening statements. It's brief and I will try to hit the highlights, but I wanted you to have this because it has citations to a number of past cases. And there's a copy there for appellants and give you one copy for the court report.
yes.
Thank you.
Members of the panel, first, I always begin by saying thank you for your service. We know this is not a high-paying position. And even more so, typically we hold these during the school year, but this is not during the school year. And so our teacher member here is giving time too. So we do appreciate, because panels are the way that this law is implemented and carried out. Fair dismissal law has been around since 1971, modified in a few instances, but largely the same. And one of the things we note is that the legislature gave us specific grounds but did not for termination, but did not define those. So I want to very briefly just review the interpretation of the grounds that have been named here, because those interpretations have come about through prior cases heard by panels just like you. Those interpretations have in most cases been reviewed by the Oregon Court of Appeals and sometimes the Oregon Supreme Court. So they have become not law, but they have become an interpretation of the law that's recognized by the courts and by their dismissal. So if we start with the grounds of insubordination, which is one of those named by the superintendent and adopted by the board in this case, that's been defined as a disobedience of a direct order or unwillingness to submit to authority. And we believe that in this case, both of those are present. There are court decisions that I cite there that go way back. But in this case, the evidence will be that the teacher, Julian Walker, refused to comply with a direct order by the governor, the Oregon Health Authority, and the district to be vaccinated prior to October 18th, 2021, or to request an exception due to religious belief or medical condition. And thereafter, if an exception is requested, that teacher must comply with the safety requirements that are established by ODE and OHA and implemented by the district. So insubordination there is, I think, a fairly simple matter of whether or not this teacher refused to comply. She did refuse and indicated she would not be vaccinated, but that's not the end of the inquiry because vaccination is not required, was not required. But under the OHA rule, those who do not choose vaccination must provide an exception, and there are exception statements that are included in the records, and either on a medical basis, which then requires a doctor's verification of a medical condition that might be compromised by having an inoculation, or on a religious basis, and that requires the individual to make a religious statement of religious belief. In this case, Ms. Walker refused to do either of those. And so it's not a matter of whether she then complied with any safety rules. The request for an exception is a prerequisite then for asking for any other kinds of accommodations. The second grounds is neglect of duty. And neglect of duty means, and this is an excerpt from a case that you'll see cited on the second page. It means the neglect of the teacher to a school district and students failure to engage in conduct designed to result in proper performance of duty. Neglect can occur through repeated failures to perform duties of a relatively minor importance or a single instance of a failure to perform a critical duty. In this case, we have a single instance, the refusal of this teacher to leave the failure to ask for exceptions. There was a deadline set for that. We have one of the other by October 18th, 2021. Then continuing on from this excerpt of a decision of the prior case, there is no question that a teacher has a duty to keep students safe and to refrain from negligent or intentional actions that would result in injury to students. And notice it is both negligent and intentional. So it doesn't require a malicious intent. It simply requires that there be a finding that there was a clear directive and the person neglected to follow that directive. And so the case I'm citing from Peter Porath versus Woodburn School District was one that involved a safety issue where there was no charge that the teacher had intentionally injured a student, but did actually engage in conduct that had potential for injuring the student. In this case, the appellant's refusal to follow the rules promulgated by the governor, the Oregon Health Authority, and ODE in August of 2021. That's when the rules were promulgated. And as required, the district began enforcing those rules on October 18th, 2021. The appellant refused to comply and therefore was in neglect of her duty to perform these responsibilities that the authorities have identified as necessary for the safety of students. Thus, in this case, it is not up to this panel to decide whether a particular conduct was neglectful or not. The Oregon Health Authority has made that decision. The governor initially made the decision about vaccination with the exceptions. So that decision by the Oregon Health Authority is an ongoing one because Oregon Health Authority made those rules permanent rules in March or late February of 2022. So in one way, this panel does not have to make a decision about whether certain conduct on the part of the teacher created a neglect of duty situation, because we have the authorities who the district must respond to and we're required to respond to and to implement. Those have been made by an outside authority. The dismissal letter also indicates a violation of ORS 342-865-1I, which is for any cause which constitutes grounds for the revocation of such teacher's conduct. And those statements in the letter are to the effect of maybe the district was required to report and did to TSBC. As of this time, TSBC has not finished their investigation or any action. And so this particular provision does not have an impact at this point because we really don't know whether TSBC is going to take a license. However, in the superintendent's letter and in the next paragraph, the superintendent stated at several times, each of the reasons set forth in my recommendation for termination constitute separate and independent grounds for termination. Each reason set forth in this termination would be sufficient on its own to support termination. And so that is the basis upon which the board acted. Finally, there are a number of independent issues that Ms. Walker has raised. Violation of other statutes or sources of authority, including there's continued and extensive reference to the collective bargaining provisions. However, the collective bargaining agreement contains a grievance procedure. That is the enforcement procedure. Ultimately, if that were enforced either in this case with this contract under through the Employment Relations Board, that would be a decision that would be made by the local association. No such unfair labor practice has been filed. So those matters, many of which were untimely filed anyway, are not really in play, but it certainly is not a matter for your panel to determine whether there was a violation of the collective bargaining agreement. There are many statutory provisions of Oregon and federal law that have been cited, but in all cases, there's an enforcement procedure. Sometimes it's through BOLI, sometimes it's through action in a federal or state court, but you're not empowered or there's not necessary for you to look at some of those other statutes. Those claims are outside of the jurisdiction of the Fair Dismissal Appeals Board, not an issue in this proceeding. Nor, and you may hear this, did the district have an obligation to establish remote teaching assignments at a time when the governor directed all students to have access in person. But in conclusion, you're going to hear from board members. This was a very difficult decision and painful one for them. They said so in open session. They voted 3-1 to uphold the recommendation of the superintendent. And they in no way reflect upon the quality of the teaching of this teacher, but because of the fact that she has failed to and refuses to comply with the rules that insubordination and neglective duty have been found appropriately, and this panel should uphold that decision.
Would you like to make your opening statement?
I'm going to reserve my opening statement until I present my case.
Okay, so we are to the point where we're ready to call our first witness. Sarah, would you like to take a quick break, work on that, or are we going to go ahead with, because she's here? Okay, so we'll go ahead and move forward with our first witness because she is here.
Thank you, Mr. Chair.
Yep.
With the board members, I do have some necessity to fit into some schedules. Some of them are on their way to vacations and so forth. So I would plan to call the board members beginning at 10:30. I hope to finish up by 11:30 thereabouts. If we hopefully have finished with direct examination of this witness, we can move right into that. Otherwise, if we're already in cross-examination, we can take a break.
Okay.
All right, thank you. Is the witness supposed to be over there? Is that correct?
I can't see over there. So
We can just leave her right where she's, I mean, is that, everybody good with that? That we can, you can just stay in her chair.
Okay, you can stay right where you are.
Okay.
Okay,
I need to administer the oath before we get started. So can you please state your full name and spell your last name, please?
Jodine Lee O'Mara, Omara.
And raise your right hand. Under penalty of perjury, do you solemnly swear or affirm that the evidence you will give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
I need to remind you that your testimony is being recorded. It is therefore important that you give audible responses that are clear, such as yes and no, rather than slang or just nodding of the head. You may proceed.
okay. May I call you Jody?
Yes, please.
Jody, what position have you filled most recently for the Mapleton School District?
I was the superintendent and elementary principal for 10 years.
And how did that change recently?
I retired July 1st.
Okay. Prior to the time of your service as superintendent and elementary principal, did you work for the school district?
No,
Did you have other prior administrative experience elsewhere in the state or teaching experience?
yes.
And where was that?
I started teaching elementary school in Roseburg, Oregon. And then I moved to Florence and taught for 11 years in middle school and elementary school. And then I was an elementary principal in Coos Bay for 5 years and then became the principal superintendent in Mapleton.
Okay, thank you. Do you hold degrees from higher institutions?
Yes, I have my bachelor's degree from Western Oregon State College and my master's degree from University of Oregon.
And what licensure do you hold?
I hold a superintendent license.
Okay. So you've lived in Mapleton for 10 years?
Actually, I've lived in Florence for 25 years.
I see.
So
Okay.
yes,
Did you know Julene Walker prior to the time that you came to the district?
Yes, I did.
And how was that?
She went to school in Florence where I was teaching and actually was on a basketball team that I helped coach.
And approximately what age was she at that time?
Teenager, 13, 14, 15, long time ago.
Okay. Have you been in her classroom during those 10 years that you've been in the district?
Yes,
Now, she was hired, I believe, 4 years ago.
2017, I think it was.
Okay. And I think that's in the record in terms of some documents she's placed in the record. If you turn to the exhibit. Table of contents. But I was going to ask you just to identify a number of the exhibits and how they relate to the decision making that you went through. Let's give a little background here about how your district was impacted by COVID beginning in March of 2020 when the governor ordered the schools closed.
So we moved at the beginning, right before spring break, our entire school district, pre-K 12 moved to online learning for the remainder of the school year. And so we provided the opportunity for students to learn virtually and teachers to teach virtually.
Okay. And then during the 2021 school year, what was the situation for your district? I know that it varied because of incidents of in your county or whatever, but if you remember what point students came back in what form?
So we started the year in online learning. Teachers and staff were on site. That was the expectation at the beginning of the school year, even though they were teaching virtually. Students were, so it was a virtual learning environment for our students. And then I believe it was January or February, it kind of all runs together. But in the spring, we brought the students back on campus. For middle school, high school students, it was in person every day. For our elementary students, it was every other day. And that was based on numbers, class size, space available, following the safety protocols put forth by ODE.
Okay. Now, in the summer of 2021, did you receive notice that there were some requirements that were being placed upon school districts by the governor and by Oregon Health Authority?
Yes, we did.
If you look at your notebook, exhibit D1, and can you identify, is it a document that you reviewed?
Yes, it's part of an email that all superintendents and school districts received regarding the vaccination requirement.
Okay, and that's a vaccination requirement for?
COVID-19.
And for what portion? Was it for students or was it?
No, it was for staff.
For staff?
Yep.
Okay. And then if you look at D2, this is a document apparently from the Oregon Department of Education. Again, is it something that you reviewed?
Yes.
It talks to Oregon school and district leaders, and I think the date on here is 9/9/21. Was school in effect in place at that time?
Yes.
Okay. Before we proceed further, I'm going to ask you about D3. Can you identify what this document is?
I'd like to make an additional objection to this particular exhibit for the reasons I outlined in the email that I sent prior for inaccuracies and within the timeline itself. So I'm just making that objection. And there were some other that contains hearsay as well. So
If I may lay some foundation. This document, it doesn't indicate where it came from. So how did you happen to come upon it?
I created it.
Okay.
I created it based on notes and my calendar and events.
Okay. And was it something that you added to as the year went on or?
Yes, yes.
Okay.
Yes.
So, Mr. Chair, we are not submitting this as being a document that is by any outside authority, but it's just simply an aid to the panel and to the witness here. But it is her recollection and documentation of some varying events at different times. And so we're going to be able to, through her testimony, establish those.
Okay, so that would be an overruled on the objection.
Okay, thank you. So it notes here that on August 19th, you notified all staff via email about the vaccine mandate. Would you turn to Exhibit 4? And is that the notification that you are referring to?
Yes, that's the one I sent to all staff.
So the names here, this comprises the total staff of your school district
Staff and school board members.
and
Yes,
school board members. Okay. How many board members?
5.
Okay. So approximately how many staff, both classified and licensed, do you have in the district?
At that time, approximately 36.
Okay.
Yeah.
All right. And the appellant was a high school teacher, is that correct?
Correct.
You know how many teachers specifically serve high school, or is it a middle school, high school?
It's a middle school, high school combination, and at the start of this school year, which was the 21-22 school year, we had 6 high school teachers.
Okay,
We were a little short-staffed.
all right. What was the purpose of sending out D4 before the school year started?
I knew staff would have heard about the governor's order, and I just wanted to let them know that we're aware of it and that we're going to put this together and to just kind of calm some anxiety that I'm sure some.
Okay. And at the bottom, it says, in the meantime, if you have any questions or concerns, please share with me. Did you have any contact from any staff at that point about the issue?
I honestly don't remember if I had any conversations with staff on between the 19th email and then when we had when the next email came out. To my recollection, no.
Okay, if you turn to Exhibit 5, this document, August 31st, is the date. Vaccination mandate information. Were your staff back in either school or in service?
Yes, that was in service week. They started on that Monday.
Okay. And you state that there's some information that's attached. So did all staff members receive this full package?
Yes, so at the district welcome back meeting, they all received the packet as well as the PowerPoint. I went through the PowerPoint. Your welcome back meeting, talked about the rules, talked about the expectations. And then I followed up with all staff with this email, so they had also on it.
Okay. And is that PowerPoint the last 10 pages of this?
Yes,
exhibit?
yes.
You have a little bit of additional information at the bottom of the opening page of D5. Please remember, by the end of the day, Tuesday, we're to be declared one of the following. And what was the basis for your information that they would need to do one of these 4 things? And where did that come from?
So I coordinated with Pace, our insurance carrier and attorney, just on what needs to happen and what is the expectation around this. Every school district in the state was having to deal with this. And so while every district set different deadlines, this was the one that I coordinated with Pace to make sure.
Would you clarify what PACE is?
I'm
or
sorry.
How it serves
Pace
the district?
is our insurance carrier through OSBA. And so PACE provides all liability and coverage for the entire school district in the state of Oregon.
What was your understanding about, and it doesn't need to be technical, about what PACE's role would be if there were, students or staff who could trace a COVID infection to exposure at school? Would they cover you?
No, we were told if districts did not follow the vaccine mandate and or safety protocols expected through ODE and the Ready Schools Safe Learners, that we would lose PACE coverage.
Okay. So at that time, when you had this opening school meeting, in-service meeting, was that the start of a full week, or how many days did you have in service?
It was Monday, Tuesday, Wednesday, and Thursday. So it was 4 days that week.
All right. If you turn to Exhibit 6. Now, this is from Friday of that week, I believe. And it is a letter to Julie Walker. Refers to, I think that you had some contact with her at that time. How did that come about? Did she initiate it?
Yeah, we had a couple of individual meetings, one on the 23rd of August and one on the 31st of August. This email is in response to some of the questions and concerns she had regarding additional safety protocols that staff would, exceptions would be expected to follow in order to continue in their role in the district.
At the bottom of the page, there's an excerpt from Keith, and you have incorporated here about the logistics of the testing. And can you identify who Keith is, if you know?
So I had contacted OHA, which was the company, the group that was providing at-home testing for staff members, so that they signed up online, and some of the questions that Julene had regarding the testing and signing up and the logistics of it all, I didn't have the answers to, so I reached out. Keith is the one from WVT, which is Willamette.
Valley something.
Yes, it's Willamette Valley Toxicology. So that's who OHA, and you can, on the second page of it, it tells you that he was the contact at Willamette Valley Toxicology to discuss the logistics. So that's who Keith was. He worked with them.
Okay. Was Ms. Walker particularly concerned about the testing requirement?
Yes.
And so you've identified here of what the program, what she would be expected to do if she took an exception.
Correct. One of the expectations was weekly testing.
Okay. Were there other expectations for those who took an exception?
Yes, they had to mask at all times inside. They had to, when they were eating, if they were removing their mask, they needed to be by themselves or eat outside if they were around others. They had to maintain 6 feet distance as best as possible. Depending on their job description, if they were a bus driver, they had to keep the windows down a certain amount in the front and the back for airflow, had to wear a mask at all times. In the classroom, they had to keep the window open and the door open for airflow. So, and I think there were a couple other additional, things, but there were definitely different safety protocols in place.
Okay. Did you have, in the end, by October 18th, did you have employees of the district who elected to take an exception?
Yes, we did.
And did they follow these protocols?
Yes, they had, I had individual meetings with each staff member that was filing an exception. We discussed the safety protocols, talked about them. Some of them we added to and adjusted based on the need of their job description. And then they signed that they agreed to follow the safety protocols that were approved.
You indicated that you had several conversations with Ms. Walker. And let's take a look at Exhibit 7. I think this is a more general staff communication. And I think you've already testified about some of the requirements for those who take an exception. If you turn to D8, now this is again communication to Ms. Walker. And again, was there continued questioning about the safety protocols at this time?
It was, yes, and it was more, my understanding was that the concern with the vaccine as well as filing an exception was an issue, as well as some of the safety protocols, namely the signing up for weekly testing through OHA. Those were the 3 issues.
Now, among the options you list, one is to request an unpaid leave of absence from October 19th through the remainder of the school year. And why did you offer that as an option for her?
Well, my hope was, this was new. The vaccine mandate was new. The vaccine was new. And it was a temporary rule at the time. And so I wanted to give some grace in this amazingly challenging time and just say, let's take a step back and just wait and see. Maybe there's more information that comes out about the vaccine where Julie may feel more comfortable to take it. Or maybe the rules will change. In the history of COVID, the rules change just about every 2 or 3 months. So just to give some grace rather than just say immediate dismissal.
Okay. And you asked for notification by September 17th regarding the options listed above. Did you get any kind of?
The notification I got, I believe it was, we had a conversation. Yes, on the 17th, we had a conversation and she was not going to choose any of the options.
Okay. Well, we are on Exhibit D8. If you turn to page 3, can you identify what this?
So these are the unvaccinated staff safety protocols that each staff member that filed an exception, we reviewed them. And these were all approved through PACE, through our attorney at PACE, just to make sure that we were providing additional safety protocols to keep staff and students safe in relation to unvaccinated staff. And so these are all of the expectations that unvaccinated staff have to follow.
You've testified to a couple of conversations with the attorney for PACE. Did you have ongoing conversations with?
Yes, throughout the implementation of the vaccine mandate as well as this process.
And then if we turn to Exhibit D9, there's a letter that's attached that we want to. What did you indicate in this letter?
At this time, because Julie did not choose one of the options provided to her, I had notified her she was going to be placed on paid administrative leave. We just got this letter.
And how long is that going to last?
Yeah, as you placed on paid administrative leave pending dismissal. So that's this letter. That was on the 21st.
Look at the second page and look at the names that this was to. And can you identify those?
Yeah, so Steve Fraga is the UNICEF rep. So throughout the process, I was in contact with the union president as well as the UNICEF rep. Just to notify them, these are the steps I'm taking, and here's the communication, and to share that with them. And then Callan Sterling was the PACE attorney that I consulted with.
Now, the deadline for the vaccine mandate or the exceptions to go into effect was October 18th, I think. Correct. If you take a look at the next page of D10, letter that you sent to Walker. Why did you decide to place her on unpaid administrative leave as opposed to dismissal?
After consulting with Callan Sterling, our attorney, and as I previously stated, wanting to give some grace with the uncertainty of how long the vaccine requirement would last, would it become a permanent rule? I elected to put Ms. Walker on unpaid leave for the remainder of the school year, hoping that more information would come available for her to feel comfortable, like I said, taking the vaccine, or regulations might change. So it was a way for me to recognize that I really didn't want to have to terminate her, and that maybe more information would come available to allow her to continue to teach.
You cite from an OER and it states after October 18th, 2021, teachers, school staff, and volunteers may not teach, work, study, learn, assist, or volunteer at school unless they're fully vaccinated or have provided a documentation of a medical or religious exception. And can you tell us again, did Ms. Walker agree and provide any exception?
No,
And then it also states the school may not employ, contract with, except volunteer services of teachers, school staff or volunteers who are teaching, working, et cetera, unless the same conditions of one or the other are met. And during time she was on unpaid leave, did she have any option to work remotely?
no, that was not an option.
And why was that not an option?
Well, we are a brick and mortar school, but ultimately the school may not employ. So even if we were an online school, we would still have to require either a vaccination or medical or religious exception in order to remain employed within the school district.
There was reference in one document that Ms. Walker submitted, I believe, to you or to the board, where she indicated that she believed that you had approved that such an exception as a remote teaching for another teacher.
No, that was a different circumstance in a different school year. And it was prior to the vaccine mandate.
Okay, so that was the 2021 school year?
Correct. It was when we did come back in the spring of 2021 in person, there was two staff members that were medically had medical issues and were deemed medically fragile, I guess you would say. And so we allowed them the opportunity to teach remotely to provide the instruction until they were able to receive the vaccine and or felt more comfortable.
Okay.
But that was before the vaccine mandate.
And those two teachers, were they still on staff as of the 21-22 school year?
No, they had taken jobs in other districts in the summer of 2021.
Okay. So then in the 21-22 school year, after the vaccine mandate was in place, do you have anybody who is working remotely?
No,
You indicate that the school district had students back at that time. Did your county have any requirements for if the infection rates reached a certain level that you might have to go back into some sort of remote learning?
yes, Lane County Public Health had regulations that aligned with ODE and OHA regarding whatever infection rate level you were at. It could constitute you having to go back into online learning.
Mhm. Did that ever happen during the year?
No, it did not.
And in terms of Ms. Walker's teaching schedule and subject matters, what part of the curriculum did she teach?
She taught Spanish, and then she was our CTE, which is Career and Technical Ed teacher. She taught some business classes, and she managed our Edgenuity courses, which are virtual courses that our students take. It's a program that they log in and take classes.
Did they do that from school?
Yes, they do that from, some of them did it off campus, but it's a program that provides all of the instruction, and she coordinated it, make sure that they were on track to complete it in the right amount of time.
Mhm. And the other parts of the career technical program, did that involve contact with students and potential employers?
Yes.
And in what area do you make those kind of contacts? You know, in other words, is it just the town of Mapleton?
Oh, no, it could be Eugene or Springfield, Florence, Anita, anywhere. And Julian was really good at making the connections for our kids and what they needed. And she would reach out to community members. So it was all over.
Was she the only Spanish teacher?
Yes.
If you turn to the next document, now we're in March. When you placed her on unpaid leave, was there an indication that you were going to review that situation again?
Yes, the unpaid leave letter indicated she needed to let the district know by March 1st if she was willing to comply with the vaccine mandate. And if not, then we would be moving for termination.
What happened in regards to any change in the vaccination requirements under the OHA rules?
In early 2022, it became a permanent rule. And so we knew that that was not going to be changing. It was going to be a permanent expectation for districts and for staff to be vaccinated or file an exception. So that was a big change between the time of October and then March 1st.
Mhm. So this document, December D11, can you identify?
This is a letter that Julene hand delivered on March 1st to the district and to myself that requested that she be reinstated and have retroactive pay.
There's a question here about paid administrative leave versus unpaid administrative leave. What advice did you get from legal counsel about whether which of those leaves were appropriate?
Both of them would have been appropriate, but if it was paid leave, it would have been, we would have moved for immediate dismissal. And as I stated earlier, I was hoping to give some grace and some understanding. And so that's why we did the unpaid leave, because I wanted to give time to see if things would change. And so that's why I moved with the unpaid leave.
Okay. There's some reference in the last paragraph to breaching contract and violations of the collective bargaining agreement. What can you tell me about any attempt to enforce any collective bargaining agreement provisions?
There was never any conversation up until this letter regarding the collective bargaining agreement or any grievances or anything that was stated within the collective bargaining agreement regarding dismissal or suspension.
You mentioned that you had had conversations with the local president and also with the UNISERV. And at any time, did they indicate to you that they believed that there were any violations of the collective bargaining agreement and what you were doing?
No, they did not.
And did you continue to stay in communication and inform them as you move forward after March 1st?
Yes.
If you turn to Exhibit D12. This is a letter now. You're responding to her March 1st letter?
In essence, it's actually a note, just a notification to let her know that I had not received any, whether or not she was indicating whether she was going to be returning to the district and be in compliance. And so this was a pre-termination notification just to say, hey, I'm moving towards termination. And here's the reasons why, and offering a meeting to meet with her to discuss that.
Why did you offer to have that meeting before you wrote the letter to the board? Again, Julene is a great teacher, and this was in no way a reflection of that. So I wanted to meet with her and see if there were any changes to her thoughts or her opinions regarding the vaccine, the mandate, the exceptions, and the safety protocols that we put in place. And so I offered a meeting to meet with her prior to just kind of one more last chance to say, all right, can we work this out? You have other great teachers working in Mapleton?
I do. Yes, we do.
Did they all comply with the requirements?
Yes, they did.
You indicated that at least one or more took the exception.
Yes, I had staff members who filed exceptions.
Did they follow the requirements of safety requirements?
Yes, they did.
If you turn to then the letter that's attached to 12, March 4th, pre-termination. I note that the opening statement there is this letter notifies you, I am considering recommending that the school board terminate. Why were you as of March 4th using that terminology?
Again, just trying to see if we can work it out. If there was a way for her, if she changed her mind, if more information had come available regarding the vaccine, or, and potential changes to safety protocols, that might allow her to feel more comfortable filing an exception.
Okay. And then there's an appointment here that you offer on March 9th at 10 office. Did Ms. Walker attend?
She did.
Did she include you in a way that she was not planning to attend?
No, I had no communication, no
Okay.
response.
After that date passed, then if you turn to the next exhibit D13,
Mhm.
what was your next?
I hadn't received email confirmation that she'd received the pre-termination letter. And so I emailed her again on Monday, March 7th. The meeting was set for that Wednesday just to say, hey, just checking, making sure you received this. So that was the next.
Okay. And that letter was then attached again.
Mhm.
If you look at exhibit D14. When did you receive this letter? Approximately.
I received it on I believe it was on the day. Yes, it was on the day that I had sent the email saying, I haven't heard from you about if you're going to attend the pre-termination hearing or not. So I received this on March 7th.
Okay. And at the time that you received this letter, did you have further contact with your legal counsel?
Did I have further contact with my legal counsel?
Mhm.
Yes.
In this letter, there are some statements about that she's on a 2-year contract. Is that the case, that she was on a 2-year contract?
Well, every teacher in the state of Oregon is on a renewed 2-year contract. So when you move to, so that if there's a plan of assistance or a non-renewal, so everybody's on a 2-year contract.
How many 2-year contracts had she been on since her probationary period?
This would have been the first one.
So she had 3 1-year contracts as probationary, and this was her first one. Okay.
Say it a lot, man.
Oh, sorry. Yes.
Thank you.
Thank you.
All right. Then if you turn to the 15. The first statement here now says this letter notifies you, I am providing you with a 20-day notice of my intent to recommend the school board terminate your employment with the district. And why a 20-day notice?
That's required by law.
Okay. And had you had anything from Ms. Walker except for the receipt of the letter we just looked at, D12 or D14?
No.
In determining the content of this letter, did you operate with legal advice as to which sections of the statute pertain?
Yes, I consulted with Callan Sterling, Pace attorney, regarding the 20-day termination notice, what needed to be included, who needed to be notified, how it was to be delivered, all of those expectations.
Okay. And I know on the 3rd page here, we have the notice verification of sending this through. Okay. Into D16. And did you send this letter then via postal service, the regular postal service?
Yes, the March 10th letter. Yes, it was in response to her letter dated March 7th. I sent it via email as well as the postal service. That is in response to her letter dated March 7th.
The last paragraph. Why did you add that to the?
Because the district did value her services as a teacher. But we had no choice. We weren't legally permitted to allow her to continue to be employed in the district without following the vaccine mandate.
Did you have some hope that she might change your mind at this point?
I hoped, however, yes, I had hoped, yes.
Then look at D17. And can you identify what this document is?
So this is a letter that Julie sent to the school district board of directors regarding some employment grievances that she had with myself in the district.
And were any of those grievances pursued by the association?
No.
And if you turn to D18. And can you identify who Mary Ellen Mansfield is?
Mary Ellen Mansfield is our school board chair, and she was providing me with documentation regarding communication with Julie.
And there's note there that there's a possibility of having a hearing, either an executive session or an open session. Did Ms. Walker elect to have a hearing?
She did. She requested a hearing in executive session.
Look at the second page of the document. And the third page, this is another copy than she provided you earlier,
That is correct. Yes.
providing it to the school board.
Yes.
Look at D19. This is a request for hearing an executive session. And was that request granted then?
Yes, it was.
And we look at D20. How was that executive session then scheduled in relationship to a regular board meeting?
It was on the same night as our regularly held board meeting in April, so April 20th. And we scheduled the executive session to hear this hearing at the beginning of the hearing, or at the beginning of the board meeting.
Okay. We have you take a look at some later documents, then a D21. These are the minutes of the board meeting.
This is the agenda.
The agenda.
Yes.
Thank you. And so executive session there is referred to in number 4.
Correct.
Okay. Were you present during the executive session?
Yes.
I think that we have the minutes of or some minutes of the executive session. And I think that actually is in the exhibits that provided by a parent.
Yeah, I think so.
And let me ask you to take a look at that. And actually, I think I'm Ellen 111, but these are transcripts of minutes of the open session. So let's just go through the process here. After the executive session, made a presentation to the board
During executive session.
and did Ms. Walker make a presentation to the board as well. And then the board deliberate with or without you.
They asked after I did my district statement on termination, and then Julian spoke, then the board asked us to, so they can deliberate and consult with legal counsel. And so then we left.
Were you called back into the executive session?
Yes, the board requested that Julian and I return to executive session.
And what did the board ask of you at that point?
They asked if Julian was, asked the district, so myself, that if Julian chose to comply with the vaccine mandate, would the district reinstate her? And I indicated, yes, we would.
And did they ask any questions of Ms. Walker?
Yes, they asked her if she would be willing to comply with the vaccine mandate. And she said no.
Okay. Now if we look at exhibit A of
Get to that.
A111, which is in
Hold
the,
on. She objected to, what part are you objecting to?
Well, that's hearsay. She's saying what I said, and I don't think it's accurate.
I think that you'll have an opportunity to testify. Yeah.
Okay,
But I believe there are some minutes of the executive session and maybe we'll note where those are in the record and let me check my notes here about where that's located.
If it's helpful in terms of evidence rule, sometimes this is a misunderstanding, but statements made by parties, which you are as an appellant and the district is a party, statements made by parties are not hearsay.
okay,
They're considered admissions by a party. Just in terms of just a clarification of law.
okay. So if if in my cross-examination, I could address that, would that be more appropriate to address in a cross-examination?
I can't advise,
Okay,
but I can say for sure in your, when you have an opportunity to testify yourself, you can discuss everything you said and meant.
okay,
And certainly you can cross-examine any witness that may address statements that were alleged to have made by you and discuss them.
Jody, would you turn to exhibit A112? Okay, I'll just have you. Sorry. And you identify what that is.
These are the minutes from the executive session from April 20th, 2022.
Who keeps minutes?
Jaren Ricks is the board secretary.
Okay. And it notes board members in attendance. There were 4 names listed there. And was one of your board members then absent?
Yes, we had an absent board member.
Okay. Under the section that I was asking you about, under 113, it says Jody and Julene asked to leave while the board were asked to leave while the board consults with the school attorney. Was there then a consultation with the attorney while you were out of the room? Is that your understanding?
That's my understanding, yes.
The next section, you were asked to return, both of you were asked to return to the executive session.
Correct.
And it states here that the board asked Jody if district would reinstate Julene if complied with mandate requirements or exception. And you indicated yes.
Correct.
Then it states the board asked Julene if she would comply with the mandate or request an exception. And it states Julene indicated no.
Correct.
Were you present during the executive session when she indicated no?
Yes,
Is that a truthful statement that she indicated no?
as far as I know, yes. Yes,
And then you were asked to leave the session again?
yes.
Okay, more consultation with the attorney. Then if you turn to exhibit A111. So can you identify these documents or
No, I don't know what that is.
Okay.
Like, that's not this.
it states it's a transcript, so I think that they
Transcribed from the YouTube. video.
Yeah. It says it's transcribed from the following link. But again, in terms of your recollection, there's a start of the board meeting, but I want to have you look at page 2. And at that point, the board moves to action item 6.1. And I just have you take a quick look to read through this page, because I think that'll be as quick as possible to Does that correspond to your recollection of that part of the meeting?
Yes,
The statement by your board members, 2 of them made statements here about this being a terrible decision to have to make, a difficult decision. Did your board members at any time discuss that with you prior to this vote or after this vote?
One of the board members spoke to me after the board meeting regarding how hard it was.
And I'm asking only because I just want to have, you're verifying that this is what you heard in. the board meeting.
Yes.
And I guess we do have a YouTube
Yeah.
link on it.
Yeah.
Okay. Thanks. We were looking at D22. It says it's titled District Statement of Termination. Who prepared this statement?
I prepared it in consult with Pace Attorney, legal counsel.
Okay. Last paragraph, if you look at it. Well, to note that this termination was based solely on Julian Walker's refusal to comply. And why did you make that point in this presentation?
I just wanted to make sure that it was on record, that it was solely based on the failure to refusal to comply with the permanent admin order, the vaccine mandate. It had nothing to do with her teaching or her teaching abilities or performance in the classroom.
And then I think we looked at the previous document indicates that there was either one vote.
Yes.
Board judge, the whole application. P23, can you identify, do you have any role in preparing or helping to prepare this response by the board?
So, no, Mary Ellen composed this letter for Julene with the attorney. And then the only role we had was to mail it.
Okay.
So,
All right. Exhibit D24 is notice of an appeal. And this is addressed to the Superintendent of Public Instruction. And this is regarding this appeal that's here today for dismissal.
correct.
And I think that concludes all of the district's exhibits. A few other related questions here. Just checking to see if we have any other questions. I think that's all of my questions for this witness. Do we have a break before examination?
Yeah, I was in the, so we will take a quick break for let's say 15 minutes. So we will reconvene at 9:45. And we are off the record.
Wait, before you go, before we start moving, I'm sorry, I just need to. Sorry. To make it so that we can't see anything in here, I'm going to mute.
All right. There's sound coming. Okay, let's try this again. All right, we are now on the record and moving into cross-examination. Ms. Walker, if you're witness.
Okay. So Superintendent, well, I guess retired Superintendent O'Meara. So from what you know, am I required to comply with every OHA rule, government mandate, and district policy directive before I can request an accommodation as a staff member?
I don't understand the question.
So, so this is kind of so like, before I'm able to ask for an accommodation in my workplace, do I need to go outside of the district policy and the collective bargaining agreement and TSPC rules in order to follow outside rules in order to ask for an accommodation of any kind?
I don't believe so, but I don't know that I still fully understand the question.
Okay. Okay. It relates to the issue of insubordination, and something that was brought up, but I'll just move on to the next one. So does the OHA determine what the TSPC considers neglectful?
Oregon Health Authority?
Yeah, does the Oregon Health Authority determine what the TSPC considers neglectful?
No, TSPC determines what's neglectful based on either rules that OHA makes or ODE makes, or
Yes.
what the expectations are.
Thank you. In your testimony, you said that PACE approved the safety protocols. Who submitted the protocols for their approval?
I did.
And how were those safety protocols determined?
I looked at Ready School Safe Learners, the expectations that ODE had to put in place based on mask requirements, physical distancing requirements, how many students could be in a classroom in a certain space, as well as I consulted with other school districts to see what their safety protocols might be, if they were going to allow unvaccinated staff with exceptions to continue. And so I'm the one who came up with those in consultation with PACE.
Did you consult with anyone else from the district regarding those safety protocols?
Yes, I consulted with Brenda Moyer, the high school principal, and I also actually did with Randy Duval. He's our maintenance transportation supervisor, just about airflow and HVAC units and all of that, as well as when it came to bus drivers and van drivers and what expectations I was putting on any of those staff that were not vaccinated, just to make sure that they didn't go against any of the expectations or rules for transportation.
Did you consult with any school board members regarding those safety protocols?
I think I might have mentioned it to them, that this is what, I'm sure I sent it to them to say, this is what I'm looking at doing as safety protocols, but not necessarily as a consultation, just maybe more as a notification.
And did you ask any staff members get any input from staff, what kinds of safety protocols they would be?
So that was in the individual meetings. So when we had the individual meetings to go through the safety protocols that had already been listed, we had conversations based on individual job descriptions, any changes that they would have, that they suggested, well, what about this instead of this? It kind of meets the same, standard. So that was part of the individual and part of the reason for having individual meetings with each staff member that was filing an exception.
And so was there any room for any of those protocols to be changed or altered in any way in order for a person to continue working for the district?
Yes.
Did you feel you made that really clear in the individual meetings?
I felt like I did. There were some that were not negotiable,
Okay.
but there were some that were negotiable.
Okay, so could you, why were some non-negotiable and others negotiable?
Well, the vaccine, the weekly testing was a non-negotiable. That had to happen. And that was through PACE. Something that was negotiable was, for instance, working in small groups with students. They needed to do it outside if they were going to be within 6 feet, to moving that from being outside to being in a gym with 2 doors open, airflow, bigger space. But any changes to the safety protocols were approved through PACE.
Okay, so even the individual changes had to be through the PACE.
Correct.
Okay.
And that was not a PACE rule. That was my expectation.
Oh, to go to the PACE to get
Yes.
the approval.
In order to maintain coverage through PACE, yes.
You made reference to having a staff person who requested to work remotely when students were in person. And you mentioned that two staff members actually did that. If those 2 members who received that accommodation last year had been on staff this year, what would you have done if those same people requested the same accommodation? Would you have allowed it?
At that time, we were offering online school. We had moved back into full-time brick and mortar. And so no, that would not have been an accommodation we would have offered.
Okay, so what if 3 teachers would have requested that accommodation?
That's not an accommodation we would have offered.
What if the district what if all the contract teachers in the district requested that accommodation? Would that have changed the way the district enforced OAR 330191030?
No.
So you wouldn't have made any accommodations if the entire staff, teaching staff requested the same accommodation?
To work remotely because they didn't want to get vaccinated?
To request to be able to work remotely, basically.
Rather than file an exception?
Yes.
Then no. I would not have made any of those accommodations.
Okay, so if they wanted to assert their right to medical privacy and make an accommodation to be able to continue, not disrupt student learning, you wouldn't have made that.
I couldn't have.
Okay. And when you say you couldn't have, is that district policy?
No, it was the vaccine mandate. It was the OAR. I was not allowed to employ any staff member that was not either vaccinated or had filed an exception.
Okay. Thank you. And in your testimony about going from unpaid leave to paid leave, you mentioned that if you had stayed with paid leave, you would have had to gone to immediate dismissal.
Correct.
So who made that decision?
I did.
You made that decision. Okay. And so why did you make that decision? From unpaid to paid.
You mean
From paid to unpaid,
from
sorry.
paid to unpaid?
Yeah.
I made that decision based on wanting to ensure that you had every opportunity to gather as much information as you could about the vaccine, the safety protocols, the exceptions, to see where it went. At the time, it was a temporary rule, not permanent. And so things had changed dramatically since every month they changed the rules, the expectations. And so it was my hope that the rule would change, that would allow you to be able to continue teaching and come back. So that is why I moved from paid, moving to immediate dismissal, to unpaid, waiting until March.
would it have been an option to put me on paid leave? And still allow me that time to consider things?
No,
And why would that not have been an option?
because according to OAR, the vaccine mandate 333, I don't know, I have it memorized. I was not allowed legally to pay staff members that did not comply with the vaccine mandate after October 18th. We could not employ them.
So how would you describe my employment status at October 19th?
You were on unpaid administrative leave.
Okay. All right. We'll address that later. I know, because I know we've got other things, so. Just to clarify, so how long have I been a teacher at the district?
I believe we hired you in 2017,
Yeah, so it would be the
fall of 2017.
okay, so this year would have been the start of my 5th year, correct?
18, 19, 19, 20. Yes,
Okay,
yes, that's true. Yeah,
so the first 3 years, according to district policy, I'm a probationary teacher.
correct. That's correct.
So the 4th year, I was under
To
contract.
become a contract teacher, correct.
So for this school year, I signed did I sign a June 15th contract for another 2-year contract?
In June of 2021.
2021, yes. Okay. So I was allowed to be a contract teacher, or I should say, yeah, contract teacher for 1 full year and then the start of this upcoming, for this last year. Okay. So when we were in the April 20th hearing, after we made our presentations, Mary Ellen asked me a question. And since she's the one who asked the question, she's the one I responded to, I might save that for her, because, yeah, I think I'm gonna save my question for Mary Ellen, so. That's it for me for cross-examination.
Do you have any redirects?
No, I don't have any further cross-examination. Is it in the intent to call Ms. Mara as your witness in your part of the case, or is this going to satisfy both your need to do cross-examination or any direct examination?
So I'm gonna save, so the one issue I wanted to go deeper into, but I'm gonna save that for my direct examination. So I'm gonna be calling her as a witness for my direct examination of her.
Okay. All right. I have no further questions at this time.
Okay. So we're done with this witness for now.
Okay, so
Okay.
you can, we told the first board member 10:30, but I think we can get hold of her right now. That's gonna be Mary Ellen Mansfield, who's the board chair at the time. Got a number to call.
Yes.
Can I-
That's the Zoom.
Can I ask a clarifying question? Are you planning, Ms. Walker, are you planning on calling all of the witnesses twice? So if they're coming in via Zoom, are you going to cross and then excuse and then bring them back again?
So my understanding was that Ms. Hungerford is going to call for witnesses, and then I'll have an opportunity to cross-examine them. And then after she's done calling the witnesses, then I will go to direct examination of, my opening statement and then direct examination of all the witnesses. So
So they will come back.
they'll come back.
Okay.
And that's gonna be problematic with at least one witness, and maybe more of the board members. They are available this morning. I know that one of them is not going to be available after me, and that's the next one, but I know we can get Mary Ellen to testify now. I guess I would ask if there's no particular reason, can you not, for the board members, do it all in one, fell swoop? You can indicate that I'm moving beyond cross, I'm now moving into my left, because it is a limitation on some of their schedules.
So do you have anything to say? Okay, well, so I am definitely wanting to do direct examination of the board members. And so maybe we can prioritize those that aren't a time constraint. If we move into my direct examination, then I would like to do my opening statements prior to doing my direct examination, because I feel like it's the framework for my direct examination.
If the parties agree, there is discretion to take witnesses out of order to accommodate witness schedules, and that's been done before.
Okay.
It's an accepted practice. So in which case we could do an opening when it's
Could we do the opening statement now? Because I had indicated to Mary Ellen that we would take her at 10:30 and then Michelle Holman at 11, and she's particularly got a conflict for this afternoon. So I think if you're willing to proceed with your opening statement now, that will just set it back in the schedule I've given to you.
Okay,
So I appreciate that.
yeah,
Is that good with you?
yeah. that
Wait,
makes
do you
sense.
need to let Mary know what's going on? Do you want?
I don't know if she can hear us.
I can hear, yeah.
So we're going to go a little bit out of order. Ms. Walker is going to give her opening statements at this time, and then the district will do their examination of you momentarily.
Can she leave
Or
or stay?
I'll leave it up to you, Mary Ellen, if you would like to stay for opening arguments or return, and we can contact you as soon as those are done. We'll leave that up to you.
I'll stay logged in. I'm just gonna mute and take myself off video until I hear that you're ready for me, or I guess I'm confused. I thought Julene was saying she wanted us to hear the opening statements because it's relevant, or is it not?
We're going a little bit out of order, and we're just trying to protect everybody's time and doing witnesses at the same time instead of calling you back in this afternoon. So Ms. Walker would like to give her opening statements because she has not done that yet.
Okay.
So we will be with you momentarily. Thank you. Okay.
So first of all, I too would like to thank everyone for taking the time to prepare for and attend this appeals hearing. Board members, Jody O'Mara, Brendan Moyer, Hungerford, everyone on the panel. Thank you. And everyone who did all the logistics. Thank you very much for that. My name is Julene Walker, and I grew up in the Mapleton and Florence area. I have wanted to be a teacher since I was in high school. In order to do that, I graduated from Willamette University with a Bachelor of Arts in English and a Master of Arts in Teaching. This year, I would have completed my 8th year as a full-time public school teacher and my 5th year as a teacher with the Mapleton School District in Mapleton, Oregon. I have had a professional teaching license since November 15th, 2017, and I am endorsed to teach English language arts, English to speakers of other languages, legacy at the middle level, and Spanish. I was also in the process of getting my CTE licensure in business management and administration this year before my school year was cut short on October 19th, 2021. Since my first time teaching, I have strived to be a teacher who genuinely cares for my students, and I make the extra effort to help each student reach their full potential as both students and people. There has been some concern about bringing up the collective bargaining agreement and my evidence, and I would just like to address that. So in Ms. Hungerford's July 11th email, she states that all assertions of violation of the CBA are required to be addressed through the CBA grievance procedure and states that any such grievance is required to be initiated within 15 days of the grievance knowledge of an act, omission, or event giving rise to the grievance. Since I did not become aware that the CBA and therefore my contract had been violated until the end of February while preparing my March 1st letter, I actually met this criteria that Ms. Hungerford alleged that I had not met. Furthermore, the Oregon law provides for only one way for teachers to be dismissed. If the district was dealing with me as if I were already terminated, that would be a de facto dismissal. If they terminated me without following the process of the statutes, that would be illegal. The fact that the district was performing none of their duties toward me set forth in the contract, which is governed by the collective bargaining agreement, is evidence that they had already terminated me, but were just using other language to hide that they had terminated me in every possible way. So the line of questioning about whether the district was performing its duties under the contract governed by this collective bargaining agreement is relevant as proof of issues which are properly and legally allowable to be heard by the Fair Dismissal Appeals Board panel when determining whether the district lawfully dismissed me. Additionally, the issue was brought up that I shouldn't be able to bring up issues related to my personnel file. The simple denial of the district that they did not violate the statutes involving the lawful maintenance of a contract teacher's personnel file is not evidence in and of itself that this was so. However, the facts that they not only violated the law, but also the district policy and the collective bargaining agreement are evidence the district had terminated the contract unlawfully. Also, when I made a grievance, they refused to follow the collective bargaining agreement procedure to give me a hearing and a written decision regarding my grievances, which is again evidence that they were treating me as a non-employee. I was being treated as basically being de facto terminated. The people of Oregon have expressed their shared value in public school teachers through the legislature by enacting the Accountability for Schools for the 21st Century Law. This is also known as the Oregon Revised Statutes 342.085, 342.975. In addition to creating the Fair Dismissal Appeals Board, this law described the only legal and appropriate process for the dismissal of a contract teacher. This law, together with ORS 342.120 and ORS 342.726, encompass all the legislative intent concerning the licensure, employment, discipline, and dismissal of public school teachers in Oregon. The legislature has invested authority for licensure and employment of teachers exclusively in a Teacher Standards and Practices Committee and the elected boards of local school districts. The law delegates no authority for contract teacher employment to the Oregon Health Authority or any other government agency. That is unambiguous. The legislature designated the establishment of these specific standards for teacher and administrative licensure and the revocation of such licenses to the TSPC pursuant to the grounds set forth in ORS 342.175. The grounds for suspension or revocation of a teaching license are set out in the law and further explained in the TSPC rules. No authority to establish grounds for suspension or revocation of a teaching license is granted by law to the Oregon Health Authority or any other agency apart from the Teacher Standards and Practices Commission. The people, through the legislature, have established that public school teachers, after a probationary term of employment, shall have their employment with school districts governed by contracts. This provides additional protections to the employment of contract teachers above and beyond the extensive protections granted them by statute. The statutes themselves provide very specific and limited grounds for what a district may, but is under no obligation to, dismiss a contract teacher. Additionally, the statutes provide a detailed process which must be followed by districts who want to discipline or dismiss a contract teacher. This process is not optional. Contract teachers have additional protections, and districts have additional processes imposed upon them by collective bargaining agreements. Some of those additional conditions placed upon districts exceed the already stringent statutory requirements. We are here today because the district has violated the law by ignoring the process prescribed in ORS 342.850 and ORS 342.875. And these are going to be in exhibits as well. And because the district has not proven any allegations against me, which would constitute any of the grounds for dismissal outlined in ORS 342.865. Instead, the district has substituted grounds for dismissal concocted by the Oregon Health Authority, to whom the legislature has given no authority at all to make rules concerning the employment of licensure or of teachers. The Oregon Health Authority has usurped such authority for itself, even beyond that which the legislature designated to school boards of districts. The legislator has stated in the law that district boards may, but are not obligated to, dismiss teachers for certain grounds. Whereas the OHA has directed that school boards not only may, but must dismiss contract teachers for grounds outside of and completely different from those grounds listed in the statute. By directing the enforcement of its new rule to district school boards, OHA avoids having to defend the rule itself. Instead, I'm here to defend against statutory grounds for dismissal that have been grasped at, twisted, and attempted to be redefined to include my legally protected, ethical, respectful conduct as a professional contract teacher. On October 19th, 2022, I was suspended from my contract teaching position without pay. My job was listed for hiring. The suspension continued month after month. At all times, I was ready and willing to return to teaching. I did not request a leave of absence. I was suspended without pay through all of November. I was suspended without pay through all of December. I was suspended without pay through all of January. I was suspended without pay through all of February. Near the end of February, I did some research and discovered the district was violating, in order to prepare my March 1st letter, I was doing some research to do that. And I discovered the district was violating my rights pursuant to the law and the collective bargaining agreement. I made an appointment to view my personnel file and found out that none of my teacher evaluations were in the file. I notified the superintendent by letter on March 1st. I hand-delivered that letter to her. And again on March 7th of my grievances for the district's violation of the law and the collective bargaining agreement. And therefore I asked to be reinstated with back pay. After months and months of no action on my suspension without initiating a process of dismissal, suddenly, when I asked the district to comply with the law, Superintendent O'Mara made a recommendation to the district board to dismiss me. I was shown by documentary and testimonial evidence that the district has failed to present facts that my conduct contains any of the necessary elements to establish insubordination, neglect of duty, or professional ethical violations such as gross neglect of duty or gross unfitness. Additionally, I will show by documentary and testimonial evidence that the district did not follow the laws of Oregon, local district policy, or the collective bargaining agreement, and its failure to properly maintain my personnel file and to make it available to me for viewing, which prejudiced me in preparing for my hearing before the board on April 20th. The district did not follow the laws of Oregon or the collective bargaining agreement when I was suspended without pay and suspended for a period longer than 5 days without any process beginning to dismiss me. The district did not follow the collective bargaining agreement by not giving me a hearing when I filed a grievance concerning the unlawful conduct of the district, nor did the district provide their findings in writing concerning my grievances. The district did not follow the laws of Oregon by providing a plain and concise statement of the facts relied upon to support the statutory grounds for dismissal, nor were any allegations supported by statements in my personnel file on the day of the recommendation of dismissal on March 9th, 2022. The district did not follow the collective bargaining agreement in giving me adequate time to make my arguments and give testimony concerning all of the allegations against me during my hearing. The district violated the constitutions and the laws of the United States, the state of Oregon, and the Nuremberg Code by ordering me to reveal private medical information and by using fraud and coercion to attempt to get me to take medical treatments against my will. In questioning witnesses concerning my contract with the district, the collective bargaining agreement, and local district policies, it is not the purpose to ask the FDAB to make rulings on those issues, but to establish provable evidence to the statutory issues before this panel. over which the FDAB has jurisdiction. That is, whether the district, by not performing any of its duties under the contract after October 19th, 2021, including giving me a hearing and written decisions on my complaints and grievances, was treating me as a non-employee and had therefore already terminated me de facto long before starting the lawful process of dismissal. So that is the end of my closing statement.
Okay. So moving forward, you'll have your opportunity, you'll be able to cross. And then we will make the record known that you are then directing the witness and then you will cross. So we'll make that clear. So Mary Ellen is here and this is your witness. And so Mary Ellen, can you hear us okay? All right. I have to swear you in. So can you please state your full name and spell your last name, please?
Mary Ellen Mansfield, Mansfield.
Please raise your right hand. Under penalty of perjury, do you solemnly swear or affirm that the evidence you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
I need to remind you that your testimony is being recorded. It is therefore important that you give audible responses that are clear, such as yes and no, rather than slang or nodding of the head. Ms. Hungerford, this is your witness.
Okay. Mary Ellen, how long have you served on the school board for the Mapleton School District?
I believe I joined in fall of 2018.
And how long have you been a resident of the community or the school district area?
My husband and I bought a house in 2012. And then I moved here permanently, gave up my Eugene house in 2016.
During the time that you've been a resident of the school area, have you had any children who attended, grandchildren, or any relatives who attended the school district?
No.
And in your role as a school board member, do you periodically visit school events or interact in visiting a classroom?
I've visited sporting events. I'm not sure exactly what you mean. I haven't been to into a classroom, no.
Did you know Julie Walker before the recommendation for dismissal came before you?
I only know Julian through my duties as a school board member.
Okay. All right. So at the school board meeting, there was a portion of the meeting that was an executive session. Is that your recollection too?
You're speaking about the April
Yes.
2022? Yes, that's correct.
Okay. And if we look at the exhibits that have been provided by Ms. Walker, and again, go back to A112. Prior to this meeting, at what point were you become aware that Walker was refusing to be vaccinated or to ask for an exception?
In the fall of 2021, kind of prior to, there was a deadline set of a date in October, I believe. And prior to that, Jody Armaro was keeping us kind of up to date on either proof of vaccinations or the exceptions that were coming in. And so we were aware that there was one that was not complying.
Okay. And then leading into the meeting in April, did you receive a recommendation from the superintendent for the dismissal of Ms. Walker?
Yes.
I'm asking, and I don't know that you have this in front of you, but we're looking at the executive session minutes for the meeting of April 20th. You were conducting that meeting, is that correct?
That's correct. I'm the school board chair during this period.
Okay. So after both the superintendent spoke and Ms. Walker spoke, did you ask them to leave so that the board could have a discussion about the recommendation?
Yes, so we asked them both to leave so we could just kind of discuss amongst ourselves. We decided, actually, our discussion sort of led us to wanting to ask one more question to both. So we brought both back, and basically, we were trying to get to seeing if there was a compromise. So we asked, I believe we asked Jody if Miss Walker would comply with the exception, would she be able to come back and teach? And Jody said yes. So then then we asked Miss Walker if she would be willing to, at this point in April, comply with the requirements of the either a medical or religious exception, whatever which one. And she said no.
Okay. In the open meeting that followed, you were acting on the recommendation now in a formal manner, and it was part of the open session. Did you express your feelings about the difficulty as a board member that you had to take the action that was recommended?
Yeah. I think I said something to the effect that it was one of the hardest things I've deliberated or had to deliberate over in my time with the board, or facilitate something to that effect, how hard it was.
And you did vote to approve the superintendent's recommendation. Is that correct?
Correct.
And why did you do so, despite the fact that you were, as you were speaking, indicating it was a very difficult decision? It wasn't one that you wanted to make. Why did you make that decision?
Me personally, why did I vote the way I did?
Right. Yeah.
Because I believe that we have to uphold the law, and I'm not a lawyer. I can't really speak to whether the law is or the rule or whatever is correct or incorrect or unconstitutional or constitutional. My understanding is that these were the rules, and as a school board member, I felt like I needed to vote to uphold the rules as I understood them. And the reason I said it was so hard was because I do believe Ms. Walker is a valued teacher in the community.
And in terms of your understanding of the law, did you have access to a school attorney to help you develop your understanding of the law?
Yes. The school attorney had kind of been with us through this entire process and was advising Jody and then us, even in executive session, was on the phone in executive session.
Okay. Thank you. I don't have any further questions, but Ms. Walker may have some for you.
Okay.
So during the April 20th hearing, when Jody and I were both still in the room, I believe you did ask if I would be willing to compromise. Did you remember asking that question?
I remember asking the question. I don't remember the wording or how I said it. Okay.
And do you remember my response to that question?
My memory is that it was something to the effect of you felt like complying or with the exception was a violation of your rights?
That's an incorrect, like, so I don't know how much I can correct what I said at this point in time. I'm not sure how to, can I say what I said or? How do I-
So, yeah, this is where I can't advise.
Okay, well, I'll try it and see what happens.
Normally, I mean, in terms of whether.
I think that that effectively can happen during her testimony, but for her to, she's acting now in a role of cross-examiner. So for her to interject her own recollection of what she said, sounds to me like she's jumping the gun in terms of presenting evidence here. I mean, she can obviously present evidence later as to what she said.
So for a hard and fast rule would be when you testify,
Mhm.
you can certainly talk about, if you have a way of asking a question where you elicit a response, that's different, but you yourself don't want to testify at this point in time
Okay,
because you're not even under oath yet. You
okay.
will be, right?
Okay, thank you.
Sure.
All right. So that was the first question. And then when Jody and I left, you asked, you had each of us come back in, and then you asked a second question, which is, would I be willing to complete a exemption, correct? Did you ask me that question?
Yes, that was the crux of it. Yes.
Okay. Do you remember what my response was to that?
That I guess I thought I was answering the first. I believe your response was that filing the exemption or exception was a violation of your rights.
Thank you. And then
I guess I should clarify. So if you're talking about the two different questions,
Yeah.
when I asked you if you could compromise, you said that you were open to anything. So if that's that you would like to find a compromise, but when I asked if you were really willing to do the exception, that's when when my recollection is that you said that would be violating your rights. Just to kind of, if that clarifies anything.
yeah, thank you. So you mentioned in your previous testimony that Jody was keeping informed about staff's compliance with the ruling OAR 333-019-1030. So how frequent was her updating of the board, would you say, like to the best of your recollection? How much was she updating you guys on that in the fall? So like, let's say between August 30th through October 19th, how much was she keeping you guys up on that?
So at some point in the fall, and I don't remember exactly when, we began having weekly quick Zoom check-ins every week. So we were getting weekly updates at some point. Whether when it started, I'm not sure. I would say, but just kind of remembering that time period of when we were between the time when the up until that point when in the October deadline, I would say we heard from Jody not less than once every 2 weeks, before we had started the weekly meetings.
Okay, thank you. Moving on to the April 20th hearing, or like back to it, I guess. How long would you say the school board deliberated during the hearing on April 20th? If you were to give like a rough estimate of time, how long did you guys deliberate during the hearing itself?
You mean when we asked you to leave the room and then talked amongst ourselves?
Yes.
20 minutes.
did the board deliberate outside of this hearing at any point in time regarding whether or not to accept Superintendent O'Mara's recommendation for dismissal?
No, not that I recall. We got updates. Now I'm getting, I'm trying to remember. We never deliberated. The board never talked amongst themselves. We were updated as to how, Jody kept us updated on how things were, letting us know that when the letter went out to you and things like that, but the board never deliberated until the April 20th meeting.
So would you say it's safe to say that the total amount of time that the board deliberated together was 20 minutes for my particular case?
Yeah. Yes.
And did you say that this was a very difficult decision for you to make?
Yes.
So if it was a very difficult decision for you to make, why did you allow for the deliberation only to last 20 minutes? Was there not more things to consider?
Because when I said the decision was difficult to make, it's a difficult, where I feel like we're caught between a rock and a hard place between the law and again, I'm speaking personally, I shouldn't speak for the entire board. I had trouble with the decision because I felt like the law says one thing that was, for me, pretty black and white, that you had to get a vaccination or request an exception. So I felt like I had no choice, but my appreciation and respect for you as a teacher made that very hard to do, because I have such, even though I don't know you personally or, outside the school, and I don't have kids in the school, what I have heard or believe or have seen in board meetings is that you're a very good teacher and good for our community. So it was a hard decision for me to make personally. But so that made it hard, but I didn't really feel like I had a choice. There wasn't really a deliberation because for me, the rule was clear.
Okay. So I'm doing my cross-examination, like to move to my direct examination, unless.
The district has an opportunity to.
Yes, just on redirect, the minutes of the executive session indicates that after Jody and Julene were asked to leave while the board consults with school attorney, did you consult with your school attorney regarding your understanding of the law?
Yes,
I'm talking about on that particular occasion. Did your school attorney confirm for you your understanding of the law that you just testified to, that you didn't really have a choice if she would not take an exception or if she would not get vaccinated?
Yes, the school attorney advised us that these were the rules, and there was no way to bring the Ms. Walker back without either a vaccination or an exception.
Thank you.
Okay.
Yes.
I'm finished.
You have an opportunity to recross if you would like to use that at this time.
I think my direct examination will bring forward what I would like to ask in my.
Okay.
Yeah.
We're moving forward into your direct examination.
So how did you find out that I was not being paid or allowed by the district to fulfill my teaching duties on October 19th, 2022?
I believe either we were forwarded a copy of the letter that was sent to you, or Jody informed us in one of our meetings within executive session.
So was that the September 21st letter or the October 18th letter, both of those, or just one letter?
I don't recall. As a general statement, I'm going to say, I feel like we were kept very apprised of everything as it happened, and we received copies of things as Jody sent them to you, or so, you know, whether or not we saw one letter here or there, I can't at this point state. But my general statement is I feel like we were kept very apprised.
Thank you. What steps did you take in your role as a school board member to ensure the prevention of my working and being paid by the district, that my prevention of my being able to work and be paid by the district was being done lawfully? So did you take any steps as a board member to make sure that that happened lawfully?
Not beyond listening to the advice of our attorney and Jody. And then this isn't a step I took, but I am also employed by a school in Oregon. And what I was hearing from Mapleton was consistent with the message that the school that I work for was sending out.
Thank you. Are you aware of the laws that govern the dismissal of contract teachers?
No. I mean, not except as they've come up in this case.
Did you find that the district statement or district's treatment of me since October 19th, 2021 was done lawfully?
I'm not a lawyer. I believe that the district followed the correct procedures.
Did you find that the district's treatment of me since October 19th, 2021 was done in accordance with the collective bargaining agreement and my June 15th, 2021 contract?
So it's the way I understand this is that the kind of new, I'm going to say law, I don't know what it is, the new guidance from OHA or the new requirement to be vaccinated or claim an exception sort of supersedes some of that, or supersedes the collective bargaining agreement and the contract.
So you're saying that this OHA rule that was enforced by the district supersedes collective bargaining agreement and my contract?
That's my sort of general understanding of it, yes.
Did you discuss my employment situation with any other board members outside of the executive session and school board meetings?
No.
Did you read the grievance email and letter that I sent to the school board on March 15th, 2022?
Was that the
That would be
document 120 pages or so, that PDF?
Yes, the 115. No, not that one. It was on March 15th. Excuse me. Actually, can I see this? Yeah. It would be Exhibit 1, A1. So that has the email, the letter attached. Well, has a letter attached. So the March 15th. I sent it to you on March 15th by email. And I also sent a certified return receipt request.
Yes, I read that.
Okay. Did you also read the defense against termination recommendation email? So this would be Exhibit A43. This is a 28-page document with 31 exhibits sent to the school board 8 days prior to the school board meeting on April 20th. It was sent on April 12th. Did you read that 28-page document and exhibits in its entirety before the hearing?
I read word for word, probably the first 10 pages of your written defense. And then, to be honest, I begin to skim and try and get the summary. I read your summary then at the end to try and get your main points and understanding. It got a little thick and legal for me, to be honest. And then the exhibits, most of which I had seen, not your evaluations, but just so those I did not read word for word. I skimmed and got the gist of them.
So you're saying that you read, of the 28 pages, you read 10 of the 28 pages of my full defense that was given to you 8 days prior to the April 20th meeting?
Word for word, I did, and then I began kind of trying to summarize.
And why did you not read the thing in it, the document in its entirety?
Because to fully understand it and digest it, I was getting lost. I was having a hard time. It was very legal, which I'm not a lawyer, I found it a bit overwhelming.
Did you have any concerns about the grievances I had against the district and those two documents? So I'm referring to the March 15th document where I outlined in a 4-page letter just the grievances specifically against the district, as well as the same grievances that I reiterated in the 28-page document. Did you have any concerns about the grievances I had against the district in those two documents regarding my charge that the district had violated the collective bargaining agreement, my contract with the district, and the law and the district's dealings with me? Do you have any concerns about that?
Do I, I'm trying, do I have a concern that the district didn't follow the correct process? No. There was some claims made, about whether or not things should have been in your personnel file at different times. To me, those are not the crux of the issue. So that to me, set off something. I want to make sure that those things if that is the true or ends up being true, that we clean that up in the future. But to me, that wasn't the crux of the case. So I guess when you say concern, I'm not quite sure how to, I wasn't concerned with what I believed to be the important issues of this case, which were the vaccination and the exceptions and the procedure that we followed. I really do feel like the district followed had your best interest in heart by not terminating you in October, but sort of giving this unpaid leave time so that we could see how everything played out. I'm not concerned about that.
Okay. So as a board member, what did you intend to do in order to address the grievances I brought up in the March 15th letter and in the full defense? I believe if I look at I was just going to look at which parts of the defense you read. So if you could go to the exhibit A43, because I want to make sure that you read the part that I'm just asking about. So I state my grievances. Those are all up through section 6. So let's see, you said you read through the first 10 pages, roughly from memory.
Yep, I'm getting there.
So I address my grievances, pretty much they end with the exception of, actually, they pretty much end on page 12. So do you feel like, so you read up to page, so you read 10 of 12 of the grievances in the full defense, correct? I mean, there's 28 pages, but you said you read 10 of those 28. So of the grievances, you read 10 of the 12 pages. Could you say that? Or no?
I am trying to find where you are. Obviously, this is what I'm looking at I'm scrolling, so please give me 1 minute.
Yeah, no problem.
All right, I'm gonna look someplace else because I am not following what you're saying. Okay, so I am now looking at the email that you sent on,
15, March 15th.
no, on April 12th. Isn't that what you wanted me to look
Yeah,
at?
yes.
Yeah,
Uh-huh.
okay. So, and it starts out with opening remarks.
Mhm.
Okay, and so which page of this now do you want me to look at?
So I'm just wanting to know, like, if you could kind of identify within the document roughly where you stopped reading.
And started skimming?
Yes. To the best of your memory.
I'm gonna say somewhere on page 10 or 11.
Okay. So that's the majority of where I lay out the grievances. So and again, the March 15th email was only 4 pages. Did you read the entirety of the March 15th letter that I sent you, which was 4 pages long?
Yes.
Okay. So of those grievances that I brought up, as a board member, what did you intend to do in order to address those grievances that I brought up to the board regarding my treatment?
I didn't feel like the grievances were relevant to the fact that you couldn't be employed by the school district because you did not comply with the vaccination rule.
So if a district staff person brings a grievance to the school board, what is the process that they need to go through in order to bring that grievance to the board, for them to hear it and to consider it?
I think the process that that you followed was what I would expect from another staff member. There hasn't been another grievance since I've been on the board, but I would expect that the staff member would follow the process, would do what you did, was notify the board of what your grievances were.
Did you vote to accept Superintendent O'Mara's recommendation to terminate my contract with the district on April 20th?
Yes,
Did you find that I was guilty of insubordination?
I found that you were unwilling to get a vaccination or claim an exemption.
So can you explain to me how that constitutes insubordination?
If you are being required by the state or by OHA or by the ODE to get a vaccination or to claim an exemption and you refuse to do so, I guess that is insubordination. I don't like to use that term because I don't, that to me, it's a little bit negative, but I guess that is insubordination because you are not agreeing to fulfill you're refusing to fulfill your duty.
Okay. What facts from my personnel file did you find to substantiate the claim that I was in subordination?
I'm going to object to the question in that it presumes that there is a requirement that the documents, and I know recognize that the fact is your interpretation of law, and those things have to be in, but I don't believe there's been any substantiation of that. So I think you can ask her factual questions, but I think you're now asking her legal questions.
Well, the Oregon statute requires that insubordination be, the evidence has to come from the personnel file.
It's not.
Okay, can I?
Legal disagreement between us on that, but I guess in terms of your request, your examination of this witness, I think you have to ask her factual questions about what she did or did not take into account. The legal argument that you want to make is one that we make in post-hearing briefs and so forth.
Okay, but I need to go, I'll go ahead and direct us to, because she had access, well, I'll ask her, did you have access? So when you received the pre-term or the 20-day termination notice, was there another document that was attached that was given in addition to that document? And if you turn to exhibit A3, it is the, it would have looked like this: accountability for schools for the 21st century law. And it has the Oregon revised statutes 342.805 to 342.937. Did you receive those in addition to the 20-day termination notice that Superintendent O'Mara provided you?
I don't remember.
Would you have received that by email?
I believe she sent it by email too. Yes.
Okay. Is there any way you could verify that? I mean, I can pull it up probably here.
I see a 20-day termination letter that references ORSs, and then an accountability for schools for the 20th century law with different.
Yeah.
Okay. And when did you receive that, the accountability for schools for the 21st century law?
I was looking at a March 14th email.
So why do you think Superintendent O'Mara included that with her 20-day termination notice?
Object. I don't think that she can surmise that. You'd have asked the question of the superintendent, but for you to ask her why she thinks that the superintendent sent it.
That's fair enough. Did you read the document that was included with the 20-day termination notice?
I read the kind of the bolded bullets, summarized, skimmed.
So if a contract teacher's employment is at stake, as a school board member, do you feel that would be important to take the time to read the documents sent by the superintendent, recommend all of the documents sent by the superintendent recommending that dismissal?
I think it's important to read the communication that went to you in this case, to read the supporting documents that are legal, in legal language. At that point, I guess it's getting outside of my area of expertise.
So did you see statements from my personnel file to substantiate that any directive given to me was both from someone in authority over me in the workplace? So I was given a directive of someone over an authority over me in the workplace. And two, was a directive that did not violate the laws of Oregon or the United States or violate a fundamental right protected by the Oregon or United States constitutions.
So I think what you're asking me is, do I think that the directive that came from ODE about getting a vaccination was someone who has authority over you?
Yes.
Well, yes, I guess whether it's that stated or not, if I do believe that ODE has authority. Yes.
Does ODE have authority over me as a contract teacher? Like, can ODE tell me something to do directly?
So I look at it as, I guess, you're required to have a teaching license to teach in the state of Oregon.
Yes.
And then now you are required to be either vaccinated or claim an exception. And so to me, those are, yes, that is a requirement of a teacher now. Am I answering that right? Or answering your question? I'm not sure.
So are you saying that the Oregon Health Authority is the authority over me as a contract teacher?
I'll object. That's not an accurate rendition of what she said. She said that ODE made it a requirement.
Okay, so ODE has made it a requirement. So you're saying that ODE is the authority over me. Is that correct?
Yes.
So who is responsible for hiring and firing contract teachers?
Well, in the Mapleton School District, the superintendent.
Okay, so she would be the direct authority over me then?
Yes.
Okay, so you're saying that I was being insubordinate to Superintendent O'Mara by not following the OAR ruling
About vaccinations.
about vaccines.
Yes.
Okay. So the second, so just to clarify, did you find evidence in my personnel file to prove that I was insubordinate to Superintendent O'Mara.
To me, the evidence was in our fall discussions when we were learning that there was someone who was refusing to be vaccinated and not claim an exception.
So you, as a board member, do you have the right to look at people's personnel files?
In this, I didn't ask to ever see your personnel file. If that's what you're getting at.
Yes.
I didn't ever ask to see it, to see that the correct documentation was in there. I don't even know what the correct documentation in this instance would be.
So moving on to the second charge that Superintendent O'Mara accused me of, which was neglect of duty. So did you find that I was guilty of neglect of duty, including duties specified by written rule?
When I understand that you were willing to come to work. So the way I interpret this, you neglected your duty to get a vaccination or claim an exemption.
So you're saying I neglected my duty by not the proof of vaccination and or show or get exemption. That's how you're saying I neglected my duty.
That's my interpretation, yes.
Okay. What statements from my personnel file did you find to substantiate that claim?
Again, I did not, ask to see your personnel file during that time.
What duty specified by the teacher standards and practices, and I will let you know where those are, so you can look at them. So there should A24. If you go to A24. So if you go to there, this is a 15-page document. It's the TSPC standards for competent and ethical performance of Oregon educators. Okay. And the neglect of duty this has gross neglect of duty, which we'll get to eventually, is any serious or material inattention to or breach of professional responsibilities. And then it lists
a procedural question here.
Yeah.
We do have another board member who has a time slot between 11 and 12.
Mm-hmm.
And so if you're about finished with this witness, I think that it defines it kind of finish. But otherwise, probably we're going to have to ask that we would take the other witness.
So I'm not even close to being finished with this witness, so but I'm open to adjusting for a witness that's on a more strict time constraint for sure.
Okay, so are you available later, Mary Ellen, to come back and finish my testimony?
Sure.
All right, then panel, I would ask that we be able to accommodate this other board member's schedule. You call her.
Okay. You were good with that? Just
Yeah.
pausing on this one?
Yeah, yeah. that's fine.
Okay. All right, so we will get a hold of you. Sorry, we will get a hold of you, Mary Ellen, and have you come back to finish your testimony.
And it might be after lunch because I think they've set a lunch for noon one.
Yes.
So, yeah, it might be after lunch. Okay.
She's on.
That's what kind of what you're getting at.
Yes.
Okay.
I didn't ever ask to see it, to see that the correct documentation was in there. I
That's
don't
the
even
one.
know what the correct documentation
Where is this?
is.
Is that?
That was that person. That was them.
Oh, was she listening to the live stream?
Maybe.
Have we been able to contact her and let her know that we're going to call her as a witness now?
I did message her. Oh, here she's back. She might have just spooked and just hit and leave. I do that sometimes.
Okay. There she is.
There she.
Okay. So, hello. Can you please state your first or your full name and spell your last name, please?
Michelle Holman, Holman.
And raise your right hand. Under penalty of perjury, do you solemnly swear or affirm that the evidence you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. I need to remind you that your testimony is being recorded. It is therefore important that you give audible responses that are clear, such as yes and no, rather than slang or just nodding of the head. Ms. Hungerford, this is your witness.
Yes, thank you. Michelle, I'm going to ask you a few questions about your role as a board member, first of all. How long have you served on the board?
Oh, 35 plus years.
And I take it you've been a resident of the district for that period of time.
Yes.
And have you had any family members who've gone through the schools?
All three of my kids, K through 12.
Mhm. And I think the testimony here has been that Ms. Walker has been employed since about 2017.
Mhm.
So have you had any interaction with her during those years, or did your children graduate from the system prior to that time?
Oh, I've had interchange with Julene. I consider her a friend of mine, not only a school employee, but I've known her 4 years. Yeah.
Okay. And so in your role as a board member, in the 21-22 school year, do you recall a time when you were informed about the requirements that were going to be made in order for teachers to continue to teach, that they would have to either be vaccinated or take an exception?
Yes.
What kind of information did you get from any source about that requirement and who was imposing it and why it was being imposed?
Well, for my role as a school board member, I received much information from Ms. O'Mara. Jody kept us apprised constantly with the changing landscape of what the pandemic was requiring of us.
Okay. Were there any times during that time when you were advised by legal counsel regarding those obligations of the board and the district?
Through Jody. I don't recall in that time having actual contact with legal counsel.
Now let's move forward then to the spring of the year. And do you recall the time when you received a recommendation from Jody to terminate Ms. Walker?
Yes, I do.
The records indicate that you were attending a board meeting on April 20th, and you had received a letter from this superintendent regarding reasons for termination. And looking at the minutes of the executive session, do you recall having Jody and Jolene both in the executive session?
Mhm. Yeah.
At one point, that in that executive session, you asked or board asked Jolene and Jody to leave. And you had discussion, it indicates, with your school attorney. At that point, did you have the opportunity to have any questions that you had asked or addressed by the school attorney?
Sure, absolutely.
And then there was a point where you asked Jody and Jolene to come back in and answer questions from the board. Do you remember why the board asked that happen?
I'm not understanding what you're asking. Why we asked them to come back in, or?
Yeah, right. Mhm. Yeah.
No, I'm still not really understanding. You mean why we ended up going back into open session to give our final vote?
Oh, and you're a little bit ahead of me there. Do you remember Jolene and Julian, excuse me, and Jody coming back into executive session at your request in time during the executive session?
I don't remember that. It certainly could have happened. I don't remember them coming back in.
In open session, then there were comments, opportunity for the board members to make comments after a motion was made and seconded to uphold the superintendent's recommendation or adopt that recommendation. Did you make any comments, if you remember, as to how you felt about making the decision?
Yeah. It was I've been on the board 35 plus years. This was the most emotional, difficult, heart-rending kind of decision I've ever made.
And you did vote to uphold the superintendent's recommendation, right?
Yeah, I made the motion.
Why did you make the motion to uphold the superintendent's recommendation?
Why did I do that?
Yeah. Mhm.
It was a clear-cut decision. You have to uphold the law as the steward of the school district.
Okay.
When I say it was difficult, but it was clear.
Okay. I think that's all the questions I have. But you'll have some cross-examination.
All right.
So, roughly how long did you deliberate in executive session over the decision whether or not to accept Superintendent O'Mara's recommendation for my dismissal?
I didn't keep time, but it was not long.
Did you deliberate outside of this hearing with the school board regarding my dismissal or the Superintendent O'Mara's recommendation for dismissal?
No, never.
So it wasn't difficult in that it was a hard decision. It was just difficult and that it was Why was it a difficult decision exactly again?
Well, because Julene, you're an excellent teacher and the kids deserve excellent staff, teaching staff. I never wanted to be in this position, and I always hoped that you would comply with the law and stay employed.
Could you please cite for me the law that you're referring to that I did not follow?
The governor's mandate that all teaching staff are either immunized or file exceptions, religious or medical.
So if that was the reason for your decision, why didn't you call it a mandate at that time?
It's a mandate. I'll call it that now, if that helps move this along.
Okay. It was for my refusal to follow the governor's mandate that you voted to fire me, correct?
Yes.
Okay, so that's the end of my cross-examination. I'd like to move into my direct examination. Unless-
You have an option to redirect.
I don't have any redirect on those questions, so.
Okay. Just also looking at time, we've been here almost 2 hours without a break. Do we need a 5-minute break or a quick bathroom run? I'm just going to kind of quick.
Yeah, I would appreciate that, but I do know that this witness needs to be finished by noon, so.
Okay.
Can we take 5? I'll take 4 minutes.
Okay, 4 minutes. We're going to pause the record for 4 minutes. So at 11:25, we will be reconvening.
Thank you.
Yeah. Around Thank you for that. We are now on the record, and Ms. Walker, this is your witness.
Okay. So, how did you find out that I was not being paid or allowed by the district to fulfill my teaching duties on October 19th, 2021?
Through Jody.
What steps did you take in your role as a school board member to ensure that the prevention of my working and being paid by the district was done lawfully?
I rely on Jody's recommendations.
Are you aware of the laws that govern the dismissal of contract teachers?
Nope. I'm a school board member, a citizen representing the public.
Did
Again,
you-
I rely on counsel and Jody for that kind of detailed information.
So, in Exhibit A 116, I don't know if do you have that available to you?
I do not. I think I thought that you would have that, you would split the screen and share it, but since that's not happening, I don't have it in front of me. I'm not even at home.
Okay. So I do have a email here. It's the 20-day termination letter notice that Jody O'Mara sent to all the school board members with the 20-day termination notice letter attached to it. Do you remember receiving that on March 14th?
I'm sure I received it. I don't recall every email that I received.
Okay. Did you read the 20-day termination notice letter?
I did.
At the end of that document, there was also the another document that outlines the would be Exhibit A3, which is the accountability for schools for the 21st century law. And it is ORS, the Oregon statutes 342.805 to ORS 342.937. Did you read any of that document with the laws related to accountability for schools for the 21st century?
I did read it.
Oh, you did? Okay. All right, so that is helpful. So in that document, there were laws that govern the dismissal of contract teachers. So you became aware by reading that document? Did you become like somewhat aware, at least, by reading that document in its entirety?
At the time, when I'm reading the document, I'm very aware. Months later, you're going to have, I'll have a hard time recalling details.
Okay, fair enough. Thank you. Did you find that the district's treatment of me since October 19th, 2021 was done lawfully?
I did.
Did you find that the district's statement of me, the district's treatment of me since October 19th, 2021 was done in accordance with the collective bargaining agreement and my June 15th, 2021 contract?
I didn't question that.
And why didn't you question that?
Because the rules of the game had changed, in my opinion. We were under the reality of a global pandemic, and that superseded anything. I mean, the terrain of our involvement with our environment had changed.
So you're saying when you say the rules of the game or the rules of the pandemic, so are you saying that those supersede the collective bargaining agreement and the June 15th, 2021 contract?
Yeah. Yes.
Would you also say that those supersede the law governing contracts, teachers?
I'm not an attorney, Julie.
Okay. Did you discuss my employment situation with Superintendent O'Mara or any other board members outside the executive session and school board meetings?
I think when you say discuss, I think I talked with one other board member about our sadness about the situation. And I did talk to Jody one-on-one about that same emotional sadness.
So on March 15th, I sent a grievance email and letter to the school board. It was 4 pages long. It's exhibit A1. Do you remember receiving a grievance letter?
I'm sure I received it, Julene. If it got into my emails, I don't recall everything. Like anybody, get a lot of emails. I'm sure I got it. If you sent it, I open up every pertinent piece of information from as a board member, as it pertains to my duties as a board member. And I read it in full.
Thank you. So then there was a larger document sent on April 12th. It was my defense against termination recommendation. It was in our list of exhibits, it would be A43. It was a 28-page document with 31 exhibits. Did you read that document in its entirety?
I did.
Did you also read the exhibits?
I did.
Wow, good job. Thank you. Okay. Did you have any, so when you read those 2 letters, the March 15th letter with my grievance, outlining my grievances, and the 28-page document that also listed my grievances and all of my defenses against Superintendent O'Mara's recommendation for dismissal, did you have any concerns about the grievances I had against the district in those 2 documents regarding my charge that the district had violated the collective bargaining agreement, my contract with the district, and the law and the district's dealings with me? Did you have any concern about that?
I did not.
And why is that?
Because the governor's mandate superseded all of that, in my opinion.
As a board member, what did you intend to do in order to address the grievances that I brought up in those 2 documents?
As with anything, I rely on the superintendent's recommendations. As a board member, I don't weigh in on my own. I wait to hear from our superintendent.
Okay. Did you vote to accept Superintendent O'Mara's recommendation to terminate my contract with the district?
I did.
Did you find that I was guilty of insubordination?
I did.
What facts from my personnel file did you find to substantiate that claim?
It was the recommendation from the superintendent.
So you didn't rely on any facts from my personnel file for that claim?
Not from your personnel file. I did not.
So to whom did you find that I was insubordinate?
To whom?
Yes.
To your direct employer. And that's Jody.
Did you, did you find that I was guilty of neglect of duty, including duties specified by written rule?
Yes.
What statements from my personnel file did you find to substantiate that claim?
I did not utilize the personnel file. We had multiple conversations with Superintendent O'Mara, and she's the one who gave us the recommendation that you were derelict of duty.
So what duty specified by TSPC rules was I found neglectful of fulfilling?
I don't know, Julie. I don't have the TSP rules in front of me.
You don't have any of the exhibits in front of you?
Nope. Mm-mm.
Okay. So should I still make reference to them for this, for the panel? Just what their exhibit number would be?
If they don't have the references in front of them,
Then I get the witness. It's, okay.
yeah, I mean, it's up to you. I mean, it's important to examine the witness based upon what they can understand.
Yeah, okay. All right. So I guess for reference for the panel, it's exhibit A3. Just for your reference for the rules that are outlined for TSPC. So my next question is, did you find that there was a kind of a umbrella phrase in the 20-day termination notice letter? Says any cause, I was guilty of any cause which constitutes grounds for the revocation of such contract teacher's teaching license.
Are you asking me if I recall that phrase?
No, I'm just saying, did you find that I was guilty of that? That I was guilty of any cause which constitutes grounds for the revocation of such contract teacher's teaching license?
I don't recall that specific phrase, so I really don't want to say that's the reason we terminated you.
Okay. So then that one. So in your role as a school board member, have you read the TSPC rules which outline the grounds for dismissal of contract teachers at any point in time?
I'm going to object. That is not an accurate statement of the TSPC rules. TSPC does not dismiss teachers. They might revoke a license, but they do not dismiss teachers.
Okay. So, but the grounds for which I am fired are related to not following the TSPC rules.
Yes, but that has to do with revoking a license.
And that's one of the grounds that was listed on this document that,
Right. Mhm.
yeah,
But
So-
the school board is still the one that revokes the license.
yes, and they should,
Excuse me, the school board is still the one that terminates the teacher.
yes. And I'm just going,
Correlating with the way you phrased your question, Swin.
okay. So attached to the 20-day termination, I know you can't probably see it, it's really small for you. But attached to this 20-day termination notice, there was that 21st century accountability for 21st century schools that you read. So in there, they reference, the TSPC, the Teacher Standards and Practices Commission's rules for being a competent educator and an ethical educator. Have you ever read those TSPC rules?
Oh, yeah, I have read them, but years ago.
Okay. So in there, they have a definition of gross neglect of duty. And that was one of the charges on the second page of the 20-day termination notice that I was charged of doing was being in gross neglect of duty. Did you find that I was guilty of gross neglect of duty?
I did.
So it sounds like you read them a long time ago, that you read the evidence that would qualify for gross neglect of duty. So do you remember that?
Do I remember that we terminated you due to gross neglect of duty?
No, what the TSPC rules describe
No,
as
I don't.
evidence.
I don't remember I would have to revisit those documents.
Okay, fair enough. So basically, to summarize, your finding is based solely on the superintendent's O'Mara's conclusory statements and the 20-day termination notice, and not on any other facts outside of the 20-day termination notice.
That's correct.
So again, just to be clear, did you find the facts for my conduct match the definition of conduct that TSPC identifies as gross neglect of duty? So that was the last charge that I was, actually, we're going to skip on to, it was not gross neglect of duty, it was gross unfitness. Did you find that I was guilty of gross unfitness?
I found that you were guilty of gross unfitness. And I can't reference it to TSP. It's a legal term that doesn't feel very friendly considering the respect I have for you as a teacher. But that's the legal terms that we get to work with.
So in summary, did you find that all the alleged charges in the 20-day termination notice were proven by facts?
I did.
And what facts did you use to find that I did not get vaccinated?
What facts did I use to why you didn't get vaccinated?
So not why I didn't get vaccinated, but did you have any facts that proved to you that I didn't get vaccinated at the time of your voting to dismiss me?
Well, you didn't get vaccinated, Julie. That's why we're here.
Did you have evidence in front of you to prove that?
You mean like a document that says Julene is not vaccinated?
Correct, or something along those lines.
I don't recall a document that said that you were not vaccinated. I was merely told that you refused to be vaccinated.
So someone else told you that I was not vaccinated.
Superintendent O'Mara told me that.
Okay.
I mean, and I had asked you, I believe that I'm the one who asked you in our hearing, would you be willing to get vaccinated and be reinstated in Mapleton? And you said nope. So that, I guess that also would substantiate that you did not get vaccinated.
So I believe what the question was, there were two questions. One question was directed to me by Mary Ellen Mansfield, which is if I would be willing to make a compromise. And I said that I would, but it would need to be in writing and I need time to consider it. The second question was during the appeals hearing, where when I was invited back in, you asked me, would you be willing to do an exemption? And I said that would violate my right to medical privacy and my free expression of religion, my right to, so. Were you aware this spring that I asserted my rights under the American with Disabilities Act, which is Exhibit A21, and ORS 659A.136, which is Exhibit A20, and the Nuremberg Code A23, and therefore did not reveal to the superintendent or to the board whether I had not had or had not been vaccinated. This information was contained within my 28-page defense against termination recommendation submitted to the school board before the executive session hearing. So, so just to make sure, in making your finding that I did not get vaccinated, what facts did you rely on?
That you did not put any, that we did not get a confirmation that you had been vaccinated. I mean, it's part of how we have to conduct ourselves. We have to have evidence that you did or didn't. If you don't provide evidence, then we can't assume that you were vaccinated.
Thank you. Did you find that I did not wear a mask as alleged by the superintendent in the 20-day termination notice?
I never saw you with or without a mask. I don't actually, we hardly saw one another in this time.
If not, so it sounds like, no, you didn't find that I didn't wear a mask. Did you tell me or put it in writing anywhere that the allegation that I refused to wear a mask I was alleged to not have done in this 20-day termination notice? Did you write that down to me or tell me that that was untrue? You found that to be untrue?
No, I never wrote to you about that. Are you alleging that I did, or are you just asking me that?
I'm just asking you the question.
All
Yeah.
right,
I just got questions here that I'm going through, so.
that's cool.
So another allegation is that I did not have an accepted exemption. Did you also find that to be true? That I didn't have an accepted exemption?
Yes, I found that to be true.
Did you find that not having an accepted exemption is gross neglect of duty?
Yes,
So can you list any rules listed in the TSPC rules about what constitutes evidence of gross neglect of duty? Do you think most closely lines up with not having an accepted exemption?
I cannot reference TSP rules at this moment.
Would you, did you at the time of making your decision to accept Superintendent O'Mara's recommendation for dismissal? Did you reference the TSPC rules when making your decision?
I did not.
During the hearing and executive session, did you or any other board member ask about why I did not have an exception?
Yes, I asked that question. I'm sure other board members did as well.
Did you ask me why I didn't have an exception? Or
Did
just
I ask,
if I
did I
would?
ask you or did I ask Jody?
Did you ask any other board member why I didn't get an exception? Or did you ask me? Did you ask anybody why I didn't get an exception?
I asked Jody.
Yeah. Did you consider my answer in making your finding that not having an accepted exemption was gross neglect of duty?
Yes.
And you also found that I was guilty of gross unfitness, correct?
Correct.
Okay. So referring to the 20-day termination notice, which is required by Oregon law to provide a plain and concise statement of the facts, do you think this document that you received as a 20-day termination notice is a plain and concise statement of the facts when it doesn't even cite the law that I'm alleged to have violated?
That's the document that I use to inform myself of the situation at hand. Yes.
Okay. So in making your vote or decision to terminate my contract, you said that you were following the law, correct? And when we all came back together in the board meeting, you said that you had a duty to follow the law.
Yes.
Can you please tell me which law you were following to vote to terminate my contract?
was following the governor's mandate. And as we said at the beginning of this discussion, if mandate will help clarify and not the word law, then I'll use the word mandate. There was a directive that came from the governor that we, the school district, had to follow, and I voted to follow it.
I'm just going to see if I can skip through a few because I know you're short on time. In the 28-page document that I sent you, there was a section 2 called legal background information, which explains the difference between an administrative rule and a law and outlines the difference between the two. Do you remember reading about that?
I don't remember reading about it in your document, but I do know that the district has to follow laws, rules, and they are informed by the administrative rules. So that's our policy. That's what governs the school board.
Okay. Do you know that the Oregon revised statutes, the law, grants the school boards the exclusive power to dismiss contract teachers?
Yeah.
Do you know that the Oregon revised statutes limit the school board's power to dismiss contract teachers to a specific set of grounds? In other words, do you understand that in order to vote to terminate a contract teacher's contract, there has to be like specific grounds for that to happen?
Yes.
Okay. Do you remember reading that law that gives you that power and authority?
I don't remember the specifics, but whenever I need to look at something like that, I can go right online and find it.
Okay. So in that list of grounds for dismissal, do you recall there being one listed for teachers not submitting to prescribed medical treatments?
I don't recall.
Does the law of Oregon, the Oregon revised statutes or its constitution grant any authority to the Oregon Health Authority concerning the licensure or employment of contract teachers, to your knowledge?
To my knowledge, I don't know about that, but I do know that these extenuating circumstances framed within this virus time supersede. And so it wouldn't surprise me if those ORSs that you're referring to do not address that.
Wouldn't it be within the scope of your duties as an elected school board member to know the laws which govern your powerful position as over contract teachers, like whether you're going to dismiss them or not?
Absolutely. And you're not the first dismissal that I've been a part of as a school board member. I take my position very seriously. And when I have to do those kinds of things, I will refer to the ORSs and I will refer to our superintendent and her recommendations. So yes, I'm well aware that that we have to behave. We also, it's not just the superintendent, we also refer to legal counsel. So as citizen representatives of the public, we have to defer to folks who have far more time on their hands to drill down on those wordy legal phrases and clauses.
Yeah, if you could just be patient with me, I'm just going to try to like prioritize my questions. So I ask you the most important ones. What criteria does the district board use to determine whether or not it will adopt an Oregon administrative rule from a government agency or from another government agency as part of the duties for contract teachers? So is there a criteria that the school board uses in order to say, yes, we're going to adopt these rules from this outside agency as part of what we're going to expect as a duty for contract teachers? Is there a criteria that the board uses to determine which rules they are going to apply to contract teachers?
I don't think that they're any different than the other ORSs. We go through them when the OSBA sends us either notification that things that need to be updated. We go through the old ORS and compare it to the new one. We take recommendations from our superintendent. We engage in conversation and discussion, and then we either take the new one verbatim, or we'll take clauses that we think are applicable to a small little district like Mapleton. We do that with regularity.
Okay. So you're referencing ORSs, which are Oregon, revised statutes.
Mhm.
But what I was terminated for not complying to allegedly is that I didn't follow an OAR, which is an Oregon administrative rule.
Mhm.
So are you putting the Oregon administrative rule like on the same level as the Oregon revised statutes?
I can't, they both weigh in. Are you talking about the administrative rules that speak to the ORSs, or is this a separate OAR is something different from an AR to the ORSs?
So the COVID mandate was OAR 333-019-1030. So
Yes.
that is the rule by OHA that I was fired for not complying to.
I'm sorry,
So-
I misunderstood you. And the OAR supersedes anything that we do. So yes, I would put it on a higher level.
You higher level than the ORS, the Oregon
Right.
revised statutes.
Right, yes.
So is it now a requirement for all contract teachers of the district to disclose their private medical information to the district in order to be employed by the district?
I wouldn't couch it in those terms. I would say where this specific medical situation is implicated, then yes, it's required. Other medical information, that's immaterial.
So could there potentially be future requirements for staff to disclose private medical information to the district that the district board would agree to have the district enforce?
Potentially, but I can't read the future. I really don't know. I mean, we are living in some very uncertain times. I would hope not.
So if this is a new requirement of the district, should it not be included as a duty within the contracts of contract teachers?
It probably will be. I can't speak to that, but you're talking about a contract that existed that you were hired under, and this happened after. So, I mean, I guess we could talk to your UniServe rep and have that conversation, or the UniServe rep.
So you're saying that the requirement to disclose private medical information was a condition added onto the contract that I signed on June 15th, 2021. It was an additional requirement made by the district for me.
Made by the governor, yes, that the district enforced. It's not part of your contract.
to your knowledge, did the district sign a contract with the Oregon Health Authority or any other entity guaranteeing that the district would adhere to OAR 333-019-1030?
I know of nothing of the sort.
Did the district transfer its authority over contract teachers to the OHA to the Oregon Health Authority?
We did not.
So was the OHA in any way pressuring the district in order to enforce the OHAR 333 and so on? Is there any pressure by the OHA to do that?
No.
To your knowledge, did the district incur any $500 fines for not adhering to OAR 333-019-1030?
I don't know of anything like that.
Were you aware at the time that it was instituted, that ruling, OAR 333 and so on, of the potential impact that the district's adherence to that ruling could have on the district's ability to fill their end of district contracts to staff?
No.
As a board member for the district, are you confident enough in the district's enforcement of the OHA rule to take on all of the risk of liability if one of the district staff members who chose to get the vaccination because of needing to keep their job has an adverse reaction to the vaccine that the district required them to get? As a board member for the district, are you willing to take on the risk of all of that liability?
I'll object to that statement because that implies that personally, the board member has that responsibility. There's already been testimony that the district has liability insurance coverage.
So PACE is the district, not yours, but is the district's liability insurance coverage, is that correct?
That's correct.
So has PACE said that they're going to take on full responsibility and all liability if one staff person has an adverse reaction to the vaccine? Have they made that commitment to the district?
I don't know, Julie.
Okay. I think she's supposed to be done at noon, so thank you for giving me a few extra minutes of your time.
I have no further questions for this witness.
Are we good with this witness? We can dismiss? Okay. Thank you for your time.
Thank you, Michelle.
Thank you.
Of course.
So at this time, we will break for lunch. And can we say we are back at 1 o'clock, 55 minutes from now? We are off the record.
I'll go, I mentioned, I'll meet you.
Welcome back. We are now on the record. And I'm not sure who our next,
I think we were in the middle of the direct examination by Ms. Walker of Mary Allen, board member. I had finished with my direct.
Yep. Is she going to be available?
He's now, yeah, I think that she should be available.
I'm texting her right now.
Thank you.
And I would just also like to get on the record that the format of everything is preventing me from getting some of the relevant information for my evidence. So I'm just wanting that on the record that, having to shorten my questioning to accommodate witness schedules and things like that is cutting into my ability to get relevant evidence for my witness testimony. So I just want to get that on the record. That's it.
Well, I think the only witness that we have in any way curtailed would be the last one, because she had that window of 11 to noon. And so I don't know that there are constraints with these other board members, but I do think it is courtesy for us to handle it all at one time for each board member, so they don't have to hang it in there for the rest of the day. So
Yeah.
If there is a need for additional testimony, this is one of the purposes of the adjournment, keeping the record open
Okay.
for 14 days. So after the end of this, there is a need, we could discuss it. And you'll also have a 14-day window to basically say, I need this witness, I need testimony from this witness.
Okay.
So you will have the opportunity
Okay.
to examine.
Okay. All right. Thank you.
I do understand, though, that once we both finish with direct cross, that witness is done, that it's not possible for either attorney to come back later and say, whoops, I thought of a couple questions I didn't ask. So I would definitely feel like that is an understanding we should have. Otherwise, this could go on forever, during 14 days at least. But so thus far, we've had the last board member. We finished with both parts of her cross, my direct, your cross, and so forth. So my thought is that we're through with that person.
Well, just so the panel's aware, I cut a lot of questions out, and I'm getting better at this as I go to know which questions I don't need to ask after a certain thing. So part of it is also me learning the process, but there are questions I'm leading out and not getting to because of this last person's schedule. So it's not like I could like show you, these are the questions I didn't get to. It's not that I'm going to come up with them in 5 days from now. So just so, I have evidence to show that these are the questions I was already going to ask. So.
Okay. Thank you.
Yep, she said 2 minutes, but that was 2 minutes ago, so she should be on right.
Excellent.
It always feels like a long time when there's dead space. It's quiet. It really does.
Yes, here we go. Here we go. Can you hear us again?
Yep.
Thank you for coming back. Ms. Walker, this is your witness.
Okay, so right now, I'm just gonna kind of, just so you know, Mary Ellen, kind of the main documents I'm gonna be looking at. I'm gonna be focusing on the 20-day termination notice that
Okay.
already sent out. And the long document after that was the TSPC rules, which are Exhibit A24.
I'll object. I don't believe that's correct. I think what was attached to the dismissal letter was.
Oh, I'm sorry. Yeah. Yeah, thank you. Actually, it's A3, accountability for schools for the 21st century law. Thank you. Yeah. So those are the two main ones. And then the laws that are cited in here for the charges against me refer to the TSPC rules that govern, you know, the behavior of contract teachers or teachers in general. And that's Exhibit A24. Just so you kind of have an idea of the three documents we're going to kind of be referring to. I know it's a little bit challenging having to like click on it and find it.
Okay.
So we've already addressed insubordination, the first charge. So we're gonna move on to the next charge, which is neglect of duty or, yes, neglect of duty. We started talking about that, but we had to stop midway. So in the TSPC rules, they give examples of neglect of duty. What TSP rules, so the Teacher Standards and Practice Commission, which of their rules did you find that I was neglectful of fulfilling in order to vote to terminate my contract?
I'm going to object. I think that's an incorrect reading of the document. The neglect of duty is under the provisions of 342.865(1)(b),
Yes.
not the TSPC.
Yes.
Okay.
Thank you.
We're going to sustain that.
Yes.
Okay.
And thank you. So yeah, on page 6 of exhibit, the accountability for 21st century schools, there are grounds for dismissal, and one of those is neglect of duty. So what duty, teaching duty, do you believe that I neglected? And did you find that I neglected?
So I voted the way I did because my understanding of the rules was you needed to be vaccinated or you needed to claim an exception. And I do not proclaim to know the TSPC rules or have combed through to figure out which one you are violating. I felt like I took the advice that we were given from a lawyer who does understand these rules much better than I do. And I feel like I had a good summary understanding of the issue, which was vaccination. So I do not know which is the appropriate one to apply.
Okay. So you took the advice of the lawyer to make your decision. Did you take anyone else's advice to make your decision?
No, my own counsel, I guess. I mean, how I felt. Or my understanding, I should say, of the rules.
Okay, thank you. The next part is the part down here. It says any cause which constitutes grounds for the revocation of such contract teacher's teaching license. So which grounds for revocation of my teaching license did you find?
Again, I do not understand the rules at this level for teaching licenses. I voted to terminate or to support the termination because my understanding was that all teachers in the state of Oregon had to be vaccinated or claim an exception, which was also the advice of our attorney. And I do not have a law degree and do not know which one of those was applied.
Thank you. So the next charge against me was gross neglect of duty on the second page of the 20-day termination notice. Did you find that I was guilty of gross neglect of duty?
I think I stated that previously that I understand that you were willing to continue working if you did not have to abide to be vaccinated or claim an exception. Since my understanding was that those were not the rules, I voted for termination. I do not know which one is appropriate to apply in that case.
So are you saying you don't know which of the
Which
charges brought against me by Superintendent O'Meara apply to my case, or you don't know which grounds you found to substantiate the charge of gross neglect of duty?
the second one.
Okay, so you don't know what grounds you found to find that I was grossly neglecting my duties. From
The
TSC
grounds that I don't know which one to point to in the legal document that you want me to address. No,
Okay.
I think I've explained kind of my grounds for my decision.
And just so you know, I'm not trying to like trick you up. I have to go, since there's 5 different things, I have to like ask you the questions for all 5 things. Because if it was just one, I would only have to do this one time, but
That's
I have to do
fine.
it 5 times. So I'm doing it 5
That's fine.
times. So just kind of want to like assure you, I'm not like trying to trick you into saying something you don't want to say. It's just, I have to ask for each of the charges against me. So
Okay,
just to alleviate any, like, I'm not trying to push you into a corner.
no
So-
problem.
Okay. Yeah, I'm just looking. So, what ground, so did you find that I was grossly unfit? That's the last charge. Did you find that as a board member that I was grossly unfit?
I found that you refused to be vaccinated and refused to claim an exception.
So you're not aware of any TSPC rule that I broke? Or anything in the Oregon statutes that is required of contract teachers? You're not aware of anything that I did besides what you're saying right now that I did?
Besides what I'm saying, and I am not aware that the TSPC guidelines were updated after, for COVID. So I just can't speak to any of those things.
Okay. So for all of the charges outlined in the 20-day termination notice, would you say that it's safe to say that you were going purely on Superintendent O'Mara's recommendation to dismiss me, as well as the legal counsel that you received?
And my understanding of what the rules were, yes, those three things would be accurate.
Okay, and then, so in your opinion, do you believe a mandate by the governor supersedes Oregon law governing contract teachers' employment, contract teachers' contracts with districts and their collective bargaining agreements? Would you say that that mandate supersedes all of those?
Yes.
What facts did you use to find that I did not get vaccinated?
What facts did I use to find that you did not get vaccinated? You did not submit that you had been vaccinated to the district by the deadline.
Were you aware that this spring I asserted my rights under the American with Disabilities Act, which is Exhibit A21, and ORS 659A.136, Exhibit A20, and the Nuremberg Code, Exhibit A23. And therefore, I did not reveal to the superintendent or to the school board whether I had or had not been vaccinated this spring. This information was contained within my 28-page defense against termination recommendation submitted to the school board before the executive session. Were you aware that I was asserting my rights to not provide private medical information to the district this spring?
Yeah, yes, I understood that. Yes.
Okay. So, in making your findings so just to clarify, in making your findings that I did not get vaccinated, what facts did you rely on for that?
Asked and answered.
Huh?
Asked and answered. She's already answered that question.
Okay,
I did not provide being vaccinated.
okay,
That's sustained.
okay. Did you find that I did not wear a mask as alleged by Superintendent O'Mara in the 20-day termination notice?
I did not. Mask wearing was not a part of my decision one way or another. So I guess I wasn't. Yeah, that seems irrelevant to me.
Well, on the second page of the 20-day termination notice, it states, quote, Oregon state law requires teachers to get vaccinated / wear a mask / have an accepted exemption. Your refusal to, in brackets, get vaccinated / wear a mask / have an accepted exemption renders you unqualified to perform your professional responsibilities of a teacher because a school cannot lawfully employ you unless you get vaccinated / wear a mask / have an accepted exemption, end of bracket. Such conduct may constitute gross unfitness and be cause for revocation of your teaching license. So that's why I'm asking you if you found that I didn't wear a mask, because that's one of the additional charges against me in that paragraph. Did you find that I refused to wear a mask?
I did not find that you did not wear a mask. Sorry.
Okay, thank you. So So since you didn't find that, did you tell me verbally or put in writing anywhere that the allegation that I refused to wear a mask was untrue?
I did not verbally or put in writing that the mask wearing was untrue. I did not.
Could
Or
that have
not
been,
found. Sorry, go ahead.
no, forgive me, sorry, I thought you were done. Okay, so could that have been something that you could have included in your termination notice to me on April 21st? That you found that ground, you did not find that ground to be true?
Yes, we could have taken that out. It wouldn't have, I don't see how it would have changed anything, but that piece, it is my understanding that you are willing to wear a mask. So if that was the only issue, yeah, we could have, I guess. I don't know legally, like if you say the A/B/C, if you're saying all of these things or any one of these things. I mean, this is the level of language and legal terms that I don't know. So since I guess what you're asking is, I did not take it out. Could I have taken the mask wearing out? Potentially. Again, I would probably want legal advice because I'm not really sure if it should have been taken out or it isn't,
Yeah, thank you. Yeah. Okay. So another allegation is that I did not have an accepted exemption. Did you find that to be true? That I did not have an accepted exemption?
That was we were told that was the case, that as of the deadline, you had not submitted either a record of vaccination or submitted an exemption or exception, whichever that correct term is.
And who told you that?
Superintendent O'Mara.
Did you find that not having an accepted exemption was a gross neglect of duty?
You're asking me to speak to legal language that I found that not having a vaccination or that one of the exemptions meant that you couldn't work in the schools. To me, the rest is just language, and the end result is the same.
During the hearing and executive session, did you or any of the board members ask? Actually, no, I've already asked this question. Forgive me. And I just have to ask it for the other grounds that I was charged for. So did you find that not having an accepted exemption was a gross neglect of duty?
Again, not having a vaccination or an exemption meant that you couldn't work in the Mapleton schools. The language, I can't speak to whether that was the appropriate language.
Okay. Would you say that you understand the difference between a rule and a law?
A rule, are referring to an Oregon administrative rule?
Yes. So do you understand the difference between an Oregon administrative rule and a law?
Not that I could rattle off the top of my head. And when I need to understand that for my work, I look things up. But no, I'm not going to try and rattle off a definition right here.
Do you remember in my 28-page defense, there was a section 2 called legal background where I outlined the difference between a rule and a law. Do you remember reading that section 2?
I remember reading a lot of legal information in your defense, in your statement.
But you don't remember me making a difference or showing the difference between a rule and a law.
So I'm not saying I don't remember that you did and read it, but could I, because you explained that in a paragraph for a document that I received back in April, that I could now still recall that and explain it now, I cannot do that. I do not have that kind of recollection.
Do you feel confident that you understood the difference between a rule and a law at the time of voting to accept Superintendent O'Mara's recommendation to terminate my contract? Did you understand it at that time?
I felt confident that the lawyer understood it and that
when you made your decision at that time, did you make your decision to terminate my contract based on an understanding that I had violated the law?
I made that determination based on understanding that you had violated what was being required of Oregon teachers.
Do you think that what was being required of Oregon teachers at that time, was it a law? In your mind, did you think it was a law that I wasn't following?
I'm not sure. I guess it didn't matter whether it was a law, a rule, a statute, an edict from the governor. To me, they're sort of all the same. To me, it's what you're supposed to do.
So just to clarify, so are you stating right now that to you, in your mind, a mandate, a rule, a law is all the same? Like they're kind of on a level playing field in terms of like their authority over one another, which has more authority?
I'm not saying that they're all the same on the same playing field. I'm saying, for me, for example, I'm a rule follower. I don't even like jaywalk, and I don't know why. I don't know if crossing the street outside of a sidewalk is a rule, a law, a traffic law. I don't know. I just don't do it. So I don't. It doesn't matter to me. I guess is.
So if there was a rule that someone told you to do, but it violated what you believe was your right as a citizen of the United States, would you still follow that rule if you felt like it violated your rights?
That's too arbitrary to ask. I certainly understand that you feel that, and I 100% respect your pushing back and the that you're all of this. I have 100% respect for you because I understand that you feel that way. And I think you have every right to, push back and do what you're doing and have this hearing. I've never faulted you for that. I can't say whether I would do it if I disagreed because it's arbitrary or not arbitrary, but it depends on what the issue was.
So you're saying if something, it kind of depends on what it was that was being asked of you, is what you're saying. If it was something that clearly violated, like if someone wanted to come in and, take over your home without your permission, would you feel like that's a violation of your rights? But the governor said it's okay, so it's got to go with it.
I mean, so no, but this is sort of, no, I don't. I've stated, Julian, that I support what you're doing. I don't understand why it matters what I would do, but
we'll move on.
Okay.
So to your knowledge, there's no law. Is there any law that I violated to your knowledge?
To my knowledge, law, no, I don't know. No, no, let's just move on.
Okay. Considering the actions that have been requested of school districts around the state of Oregon during the COVID-19 pandemic to enforce this ruling from the Oregon Health Authority, OAR 333, so on, do you think it would be important for school district board members to be able to define a mandate, an administrative rule, and a law? Do you think having just a very basic understanding of those differences would be important for a board member sitting on a school board during these times?
I think it's important for board members to be present and pay attention and to try and understand what's going on. I think it's important to have good legal counsel and advice. Do I think a board member has to understand the legal details as you just laid out, or the difference between this and this and this? I think every board member brings different expertise to a school board. And as I've stated, that is not my expertise. Give me a budget, give me some numbers, I'm your girl. Give me legal language, I'm going to listen to a lawyer.
Okay. So, give me for one moment.
Sure.
So are you aware that there are specific Oregon revised statutes, which are Oregon laws, that give you the authority to terminate a contract teacher? Do you know that that's within your power to do?
I guess my understanding was that the superintendent recommends hirings and terminations, and the board kind of approves or not, or doesn't approve those recommendations.
And where did that understanding come from?
The fact that when we in board meetings, both at Mapleton and at the school that I work for, we, hirings are presented to the board and approved, and terminations the same way. Not that there's been
Okay. So there's in that accountability for schools for the 21st century law that was attached underneath the document. That was my 20-day termination notice. There's specific Oregon statutes that outline the process that has to be followed for a superintendent to put a contract teacher or any teacher on suspension and dismiss them. And then there's a process that the school board's involved with as well. So have you read any of those statutes related to the suspension and termination of teachers that kind of govern your behavior as a school board member?
Not in the detail to evaluate or lead that process.
So if I was unlawfully suspended in October 19th, 2021, if that were the case, would you have known if I was unlawfully suspended at that time?
Is your question that you were unlawfully suspended because the correct process wasn't followed? Or is your question that you were unlawfully suspended because you did not have a vaccination or an exemption on file?
So can I answer her questions?
I think she's asking you to clarify.
Okay.
Your question.
Okay. I'm happy to. So can you repeat your question? I was just caught off guard by that. So yeah.
Well, so no, I guess I'm not clear if you're asking me. Maybe let me just try and answer. I believe that, and I understand what you were terminated for, which was the not being vaccinated or not having an exemption on file. I also believe that, no, I won't even go there. Do I have an understanding of the process of terminating a teacher well enough to know if, at the right time, the right piece of paper was put in the file, things of that nature, sort of more of a procedural thing. If those, I believe they were followed. I believe that they were done with the best intent or attempt to follow the right procedure. Whether they were or not, I am not going to try and to stipulate that, oh, this paper wasn't put in a file at this point, so the process wasn't followed correctly. Because to me, I understand that process and procedure are important, but to me, it doesn't change the reason for the termination.
So if I was treated unlawfully as a contract teacher on October 19th by not having been allowed due process that's I'm protected by ORS 342875 about suspension reinstatement, as well as 342.895 contract teachers procedures for dismissal or contract non-extension and appeal. So there are laws that are written to protect contract teachers so that they are treated fairly in the process of being suspended or terminated. So would you have known whether or not the district was acting lawfully in their treatment of me on October 19th when I was not allowed to work and was receiving no pay? Would you have known at that time?
What I knew at that time was that the district was doing the what I believe was the kindest thing at that time, which was not terminating you on that day, but actually doing a suspension that would allow more time to pass and maybe more the law to change or something so that you could stay. That's what I remember. And that's the only really part of the process that I remember, is that we chose not to terminate. At that point, we chose to do this, and I'm this kind of unpaid suspension, so that maybe the COVID situation would change, or your feelings about the vaccine would change, because it would be safer. It would be approved by the USDA. Is that right? That's what I remember, and that's all I can really speak to about the process. I cannot speak to if there was an error, or if there was something that happened that would have violated your rights. I am not aware of it. Yeah.
Okay. So in what you just said, you said that I was put on an unpaid suspension. Are you aware that the Oregon statutes that I just cited, 342.875, required me, if I'm going to be suspended if the superintendent has the authority to put me on suspension, she has 5 days to determine whether she's going to, one.
I'm going to object to this point. She was not placed on unpaid suspension. She was placed on an unpaid leave of absence.
So.
And that's sustained. And that's also a contract thing, and we have no jurisdiction over contracts.
So. But if it's relevant to the district's treatment of me as a contract teacher under the Oregon statutes.
So we're dealing with a termination. That's where our jurisdiction is.
So
the termination piece.
Okay, so part of my argument is that this is a de facto termination, because maybe I can ask her to explain the difference between an unpaid leave and a termination.
Well, I don't think this witness can clarify that. I think it is a legal question. You can make your argument in a closing statement that it was or was not a de facto. But in terms of getting on with completing the testimony of this witness, I don't think that she's able to answer a legal question like that.
Well, I think she's capable of answering the difference between an unpaid leave. What's the difference between unpaid leave and a termination in her mind? So I would like to ask that question, if the panel would allow me to do that. What's the difference between an unpaid leave and a termination?
You can ask that question. Take that question.
Okay.
And move on. Okay.
So, can I add an unpaid leave without pay and a termination?
Unpaid
Done
leave.
We're done. Yeah.
Okay, just want to emphasize that.
Okay.
Okay, so could you explain to me the difference between an unpaid leave and a termination?
Sure. So an unpaid leave has a length of time where the leave will ends, whereas a termination would have happened on that day. So my understanding is we went with an unpaid leave route in hopes of letting some time pass and things change so that we would not have to do termination. It was absolutely not a de facto termination. It was done with the intent, with the hope that we would not end up at termination.
So how would you define a termination? A
severance of employment, as a severance of employment.
Would someone who's terminated still be getting paid?
No, but there's no, of course not. But
Okay.
there is situations where unpaid leaves are the appropriate thing, and it's not a termination, at least in my experience.
So are you saying, so an unpaid, in your mind, an unpaid leave would mean that I'm not working and I'm not getting paid? Similar to a termination where I'm not working, I'm not getting paid.
similar, except that an unpaid leave leaves the door open for you to come back and work.
And who would be benefiting from that situation? For me being in limbo for months, not knowing whether I'm terminated or not.
I believed that you would benefit, and I apologize if you didn't see it that way. That was our error, because I did feel like, as passionate about teaching as you are, you would want every opportunity to come back. So I apologize if that was the wrong thing to do.
Are you aware that pursuant to the collective bargaining agreement that governs my teaching contract with the
I'm going to
district?
object to questions about the collective bargaining agreement. I think it is well established that this panel does not have any jurisdiction in terms of interpreting or applying or enforcing a collective bargaining agreement.
That's, so we give a response.
So my, I guess, argument against that would be that part of what I'm challenging here is that I was not given my due process rights. And so in an effort to deal with my grievances with the district, I made 4 attempts to do that, and they were denied to me. And I feel like it adds evidence to my case that I did not get due process in my termination. And so I believe it's very relevant to this
If
particular.
I can speak to that, concepts of due process are constitutional. They do not derive themselves from the collective bargaining agreement. The collective bargaining agreement is an agreement between the association and the district. You are a beneficiary of that, but it is an agreement between the association and the district. So while you have right to file a grievance, you don't have a right to pursue that on basic steps. And this panel is not one that can enforce a collective bargaining agreement or any inference from what you see as a failure of the collective bargaining agreement to enforce.
So the fair dismissal appeals panel doesn't have any. So like if a district denies me an opportunity to have a grievance hearing, there's no way that could be
If it-
also,
If I might help
Yeah.
out in terms of point of clarification.
yeah.
There's 2 avenues. The FDAB is an avenue, the collective bargaining agreement. The FDAB just simply doesn't have jurisdiction. It cannot speak the law to collective bargaining agreement disputes and issues. It's just not under its authority. So it can't have relevancy here within this hearing.
Okay, so I need to consider something real quick then.
Okay, so we're gonna sustain the objection that we don't have jurisdiction over the CBA.
Mhm.
And we'll go to the next question.
So just out of curiosity, then if let's just say I was suspended and I was terminated. And I tried to deal with that with the school board and they refused to deal with that. And in doing that, they also didn't follow these like 342.875 and 342.895 that by not following the collective bargaining agreement, they also didn't do these things.
Our jurisdiction is over the termination process.
Mhm.
And there's kind of 2 avenues if you go that route. And one is the grievance procedure,
Mhm.
which is using the CBA and going through the school board. And then the other avenue is this panel here. And so because we're the FDAB panel, it's just the process that we are taking.
So if the school board doesn't ever address my grievances, then who do I go to?
It's a legal question, but it's CBA, so it's,
That would be a matter of your association deciding whether they want to take that matter to either an arbitrator, but your contract doesn't have arbitration, so they would take it to the Employment Relations Board. That is only something that your association can do and not you.
without, could an attorney that I hired do that?
No,
Okay. So,
contract is between your association and the district.
okay. All right, well, I might bring this up again later, but for now, we'll just keep moving on.
Okay,
Okay.
let's move on.
Okay. So, so just to kind of get back to what happened on October 19th. So you called that an unpaid suspension.
No, she did not testify that it was an unpaid.
I wrote it down right here, word for word.
And she testified that it was an unpaid leave.
Well, no, I wrote down, she literally said the words unpaid suspension, and we can go back and look at the video recording.
We just move on with the question.
Yep.
Okay.
That's the question.
Okay. So, so do you, still agree that what I was on was an unpaid suspension on October 19th?
Do I agree on, so I believe you were put on unpaid leave of absence. Yeah, unpaid leave of absence. If I said suspension, I guess I wouldn't, between suspension and leave of absence, I don't. Yeah, unpaid leave of absence.
To your knowledge, is it a requirement that in order to receive a leave of absence, it needs to be requested by the employee? Do you know whether it's supposed to be requested by the employee, or can it be done unilaterally by the superintendent? To your knowledge, can it be, you know, who has to request the unpaid leave?
I do, I guess to my knowledge, with the Mapleton school district, I don't know. I wouldn't have questioned, I guess, a superintendent who gets the right to do that, because in my experience, I've seen it both ways.
You've seen unpaid leaves occurring both ways. Can you clarify what you mean by both ways?
I mean, I've seen unpaid leave, and I mean, outside of Mapleton, in my professional experience, I've seen unpaid leaves requested by employees, and I have seen unpaid leaves administered, handed down, I'm not sure what the right term is, from the employer side.
Okay, thank you. So in the 20-day termination notice that Superintendent O'Mara gave to me to notify me that she was recommending my dismissal, did you, hold on one second. Okay, let me go back. So in the Oregon revised statutes, so the ones that I referred to as the document that was sent with the 20-day termination notice, are you aware that those Oregon revised statutes limit the school board's power to dismiss contract teachers to a specific set of grounds? So there has to be grounds for terminating. a contract teacher?
So in time of COVID, I guess even if I would not, I feel like the COVID times are sort of unprecedented. So
Would you say that regardless of what the grounds are for terminating a contract teacher, which are outlined in the ORS, is regardless of what those grounds are, you would have still had the governor's mandate supersede those laws. Would you agree to that?
I think the bottom line of what you're asking is, I believe I supported the termination because it was my understanding that an Oregon teacher to teach in Oregon schools had to be vaccinated or claim an exception.
Okay. So, and since that was a mandate by the governor, do you agree that that mandate by the governor supersedes the laws that are outlined in this 21st, the accountability for 21st century school teacher laws that are here as exhibit 3, A3? So are you saying that that governor's mandate supersedes those laws created by the Oregon legislature?
I guess so. Yes.
So in the 20-day termination notice, it says that Oregon state law requires teachers to get vaccinated / wear a mask / have an accepted exemption. And the Oregon laws that were given in addition to this required this document to have a plain and concise statement of the facts that substantiate the charges that were given against me. So do you believe that the only reason in your mind that I was, or did you, how should I phrase this? Was it sufficient for these charges, not getting vaccinated, wearing a mask, having an accepted exemption? Do you believe that those were the grounds to substantiate all of those charges that Superintendent O'Mara accused me of? So insubordination, neglect of duty, any cause which constitutes grounds for the revocation of such contract teacher's teaching license, gross neglect of duty, gross unfitness. So even though you've established that you never had any proof that I didn't wear a mask, so we're looking at the vaccination part and the exemption part that you think, you had grounds for. So on those two charges, do you believe that those are sufficient to justify all of those charges against me?
I believe those two things, vaccination and not claiming exemption, are grounds for termination. I think you're asking me about, I feel like I'm being asked about the language again, the gross negligence and all that. And I don't care about the language. But I'm trying to give you my sort of understanding, which is, I believe those two things were grounds for termination. That Oregon teachers had to have either a vaccination or an exemption.
So the tricky part about that is that these charges require there to be certain evidence to support those specific charges. So for example, we take the first two charges, insubordination and neglect of duty. those charges have to be substantiated with evidence from my personnel file, for example. And you're saying that there was no evidence that you used from my personnel file to substantiate those charges. So in place of that, you're saying these other things that are, being requested of me or mandated by me, however you want to put it, by the Oregon Health Authority, even supersedes the evidence requirements that these laws of the state of Oregon require there to be in order to justify using these grounds to terminate my contract. And so are you saying that this Oregon Health Authority supersedes the rule the law that requires evidence to substantiate each of those charges?
I believe this question has been asked and answered, and she has answered the question. She's stated that because of the governor's order and because of the OHA and ODE rules, that constitutes grounds for termination. I think you're trying to put words into her answers. It's on the record what she has testified, and I would ask you move on.
Yep. Sustain, can you ask the next question?
So, to your knowledge, does the law of Oregon, the Oregon revised statutes, or the Constitution grant any authority to the Oregon Health Authority over my licensure or employment to contract teachers?
I don't feel that it's a school board members, honestly, to determine all that. So, I don't know. So I don't feel like it's my job to try and decide if the law or if the governor's proclamation was legal or not. It's not certainly not my expertise.
So even within the scope of your school board responsibilities to determine someone's employment based on the legality of that mandate, you still don't feel like that's not part of your role as a school board member?
Asked and answered.
Sustained.
So as a school board member, are you aware of any criteria that the district board uses to determine whether or not it will adopt an Oregon administrative rule from a government agency as part of the duties for contract teachers? So is there certain criteria that the board uses in order to determine whether they're going to take a rule from an outside agency and apply it to the district staff? So is there a criteria that's used to determine whether or not they enforce those rules?
So we have a process to review what becomes policy. Is that what you're asking?
Yeah. I mean, that would be, so,
Okay.
okay.
So we have a relationship with the Oregon School Boards Association, and they have draft policies that we review and adopt or not adopt. And then, every quarter as they make changes or update their draft policies, they will send us the updates and we will review them and decide if they're appropriate for Mapleton or not.
So is it now district policy for all district staff to disclose private medical information to the district in order to be employed by the district? Is that now part of district policy?
No.
So requiring a staff person to declare whether they're vaccinated or not is not private medical information in your eyes?
There was Oregon teachers were required to be vaccinated or claim an exemption by an October deadline.
Do you believe that this new duty, do you believe that this new requirement should be considered a duty of all teachers' contracts now? So when contracts are written up in the future, do you believe that requiring future employees to disclose private medical information, that should be part of the contract?
I don't know. I haven't thought that far ahead.
So I signed an exhibit. Second, my contract is of June 15th, 2021. Is exhibit, excuse me for a second here, exhibit A2.
Okay.
So was, in your view, was the requirement to get vaccinated a duty for me under that contract? Was it a requirement to disclose whether I'm vaccinated or not? Was that a requirement on June 15th, 2021?
I don't believe I don't know, but I don't believe in the mandate or the requirement for teachers to be vaccinated came out until this summer, but I'm not sure about the dates, to be honest.
So would you say that requiring a teacher to reveal private medical information is now a new condition of employment on top of the contract that I already signed?
I would say you're I would say these aren't decisions that I'm, let's see. I don't know. Can I just say that? I don't know.
Yes, you can say that.
Okay.
To your knowledge, did the district sign a contract with the OHA or any other entity guaranteeing that the district would adhere to OAR 333-019-1030, which is the requirement that we've been talking about here? So to your knowledge, has the district signed a contract with the OHA saying we're gonna make sure all the teachers do this, all the staff people do this?
To my knowledge, there wasn't a contract signed or a document signed.
So there was there was no pressure from the OHA to enforce this on teachers, for the district to enforce this on the teachers. You didn't feel that there was any pressure to do that?
Well, I don't know about pressure from OHA. The pressure we felt was if we didn't follow that and a student got ill, and died. I mean, would our insurance cover that? Or, so the pressure was to try and protect students. And make sure our insurance was still good, I guess.
To your knowledge, did the district incur any $500 fines for not adhering to OAR 333-019-1030? So were there any $500 fines that the district incurred for my employment specifically?
I don't believe there were any. I don't know. I don't know of any. Let's say that.
Okay. So, as a board member for the district, are you confident enough in the district's enforcement of the OHA rule to take on all of the risk of liability if one of the district staff members has an adverse reaction to the vaccine the district required them to get? So if, let's say, someone, gets the vaccination, they have an adverse reaction to it that maybe disables them. As a board member representing the district, would the district be willing to take on all the liability for a person who has an adverse reaction, a staff person required to get it to stay employed in the district? To your knowledge, would the district be willing to take on all of that liability for an adverse reaction to having received the vaccination?
I don't object to the relevance of this question. I don't believe this is tied in directly to the question about termination here. You're asking about the district's liability carry, but I don't think I think it's getting pretty far afield from the questions about this witness's decision-making in terms of terminating you.
Well, I think it's relevant to what she said earlier, because she was talking about the issue of being liable for being, someone getting sick. If someone who was unvaccinated got someone sick. And I think liability is a factor in whether or not you would choose to uphold
I
it.
think she testified that the concern was this might be liable if they did not enforce the rule.
We're going to sustain and go to the next question.
Okay. So, to your knowledge, did the district receive any funds for ensuring that all staff were either fully vaccinated or received a medical or religious exception?
Object, not relevant to the question.
We're going to sustain it.
Do I have an opportunity to say anything to that?
Yeah, if you need,
Before-
it seems to be off topic again,
Okay.
but
Well,
can you justify it?
Well, I think it's relevant in the nature of how I was dealt with in my employment, that if they're making decisions based on any kind of pressure that they're putting on me, it might show that they might have been wanting to make certain decisions about my employment based on that pressure of either not getting funding or getting funding or making people comply with a ruling.
We're going to uphold this as Yeah, and we're gonna move on to the next one.
Okay. Mary Ellen?
Yep.
So, on April 20th, 2022, I was given a hearing before the board. Is that correct?
That's correct.
What kind of hearing was I given on April 20th, 2022?
You were appealing the decision to terminate you?
So are you saying that I was already terminated prior to April 20th?
I'm not sure. We were, because the hearing was all about the recommendation for termination and what you were appealing that, I guess maybe appealing that recommendation. I am not, off the top of my head without looking at the documents, which I could do, but I'm not sure if it was, what date the termination was effective.
So you wrote me a letter, correct, on April 21st, 2022, saying that I had been terminated, correct?
Probably, yep.
So if I wasn't terminated until April 21st, how could I have appealed something that hadn't happened yet?
Because you had gotten the 20-day termination notice.
So that was, the 20-day termination was recommending to the board to terminate me. So are you saying that I was already terminated before the board meeting or the hearing and executive session on April 20th?
No, I guess not. So I guess that was our decision. The board was deciding at that meeting to go ahead with the recommendation or not. That was the question that was at hand.
Okay. So when did you receive formal written notice of Superintendent O'Meara's recommendation for dismissal?
I'm going to object. That's in the record. Some exhibits that have been submitted by appellant, excuse me.
So can I just remind her of that then? Okay.
Yeah.
So did you receive the 20-day termination notice, correct, on March 14th, was it, I believe, and by email?
Yes, I believe that's right. I can go back and look at my email.
So
Yes.
okay. So was the executive session that the board gave me a hearing in, did the board address any of the grievances that I outlined in my March 15th letter? Because I sent there was a March 15th letter outlining my grievances, and then there was the 28-page document that I sent before the hearing. So did the board at any time address the grievances that I brought forth in the March 15th letter or the 28-page document?
Not relevant. This question about compliance with the collective bargaining agreement is not an issue here for this panel.
So I think it is relevant because if it's not if I'm not given an opportunity by the district, so if they can just skip over grievances to direct dismissal, it seems like that is violating the process that's guaranteed to me in the Oregon statutes.
So
Not guaranteed to you by anything except the Public Employee Collective Bargaining Act, which is a contract, which enforces a contract between the association and the district. And the association did not choose to proceed with any kind of action relating to any alleged violation of your contractual rights, but this panel does not have the authority to make that decision.
we're going to sustain that and go to the next question. We don't have jurisdiction on that piece.
So, so I was in, if you go to exhibit A47, there's an email from you to me. So if you want to go to that A47.
And what date? It's a little easier for me to actually look at my email. I'm having troubles with all of your exhibits. If you tell me the date that the email was sent by me, I can find it.
Yeah, it's Tuesday, April 19th at 5:07 p.m.
Okay, yeah.
So at the top there, so this is in response to my question regarding, so A46 was my email to you and you're responding to my question. My original question for A47 was, am I to understand that my grievance at the same time, am I to understand that you will be hearing my grievance at the same time you're hearing Superintendent O'Mara's recommendation to dismiss me, followed by my defense of that recommendation? In other words, are the grievances outlined in my March 15th and reiterated in my April 12th defense document and the recommendation for dismissal going to be considered two separate actions or just one? So that was my question. In your response, you said, hi, Julian, let's see if I can answer your questions without making it more confusing. The board really has one decision to make if we intend to accept or reject the termination recommendation. So you stand by that statement that the one decision that the board was going to make at that hearing was whether or not to accept or reject the termination recommendation.
Yes.
Correct. Okay. So do you recall in one of your previous emails, let's see, April 46, or not, it's not April 46, sorry, exhibit A46. Second. So how long, do you recall how much time each person, so the district and me, how much time we were given to make our case before the school board? Do you recall? I think you have it outlined.
Looks like 15 minutes each.
Yes, 15 minutes each. So, in your opinion, do you believe that 15 minutes was a sufficient amount of time for me to address all of the allegations brought to me, charged against me by Superintendent O'Mara? Was 15 minutes sufficient, do you think, for both of us to do that?
Yes, because to me, the matter is all about the vaccination and the exemption. And that was the grounds for termination, and was what we were deliberating.
So are you saying that basically it didn't matter what I said at that hearing? You had already made up your mind that you were going to vote to terminate me?
I didn't say that, I don't think. I certainly didn't mean to. It did matter, certainly what you said, but I believed that the 15 minutes was enough time for you to state your case about the vaccination and the exemption.
Okay. So earlier we talked about that my grievances are pretty much 12 pages of the 28 pages of my document. So do you think I could read 16 pages of text within 15 minutes? And because that was just on the charges against me. So do you think it's possible to read those 16 pages within that 15-minute time frame?
I think the questions are getting very argumentative at this point. You submitted all of this information ahead of time. The 15-minute pre-termination hearing is not even required under the law. And just an argument about whether 15 minutes was enough or not is not a probative matter here for the determination of this panel. Especially when you're, again, asking questions about the collective bargaining agreement. You've been already told this panel does not have jurisdiction over.
That's why I separated the 12 pages dealing with my grievances and was just addressing the 16 pages that addressed the grounds for dismissal.
Okay, if you're asking about the questions about vaccination versus and exemption, whether there was enough time, then I think you make it clear for this witness that that's what you're asking about. I understood your question to be about the entirety of it and for the 12 pages that had to do with the collective bargaining agreement.
So are you saying you'd be okay with me asking it about the 16 pages?
I think she's already answered that question, but go ahead and answer that question. 15 minutes was sufficient. She answered, she said it was all about a vaccination and exemption. She said, yes, she thought it was sufficient.
Okay, so, okay.
I'm going to have to pause just for 30 seconds because there's someone at the door here.
Yes, that's fine.
While she's out, do you have any estimation of the amount of time that you have remaining with this witness? We do have another complication, and that is that Ms. Merritt here is retired, and she has plans so that her testimony, if you have questions, you put her on your witness list. She's not going to be available here in the near future.
So by the near future, meaning?
Within the 14 days, I think is.
Well, the 14 days was for if testimony needs to be scheduled, it could be scheduled within those 14 days, not to occur within those 14 days. So another date or time somewhere in the future that's mutually convenient for everyone is necessary, then that can occur that way.
Even after the 14 days.
Yes.
Period?
Yes.
Okay.
And maybe wasn't as artfully worded as it could have been.
I guess I was hoping that we'd be able to complete with this witness at least and be able to take her testimony so that we didn't have to, wait until after that 14-day period. I'm asking whether we're going to be able to complete this witness's testimony pretty quickly.
And well, I'll do my best to work through the questions. So.
Okay. Keep on here. Next question.
So who determined the format for the hearing regarding the decision whether or not to terminate me?
We were advised by our attorney.
And did the attorney also advise the board not to have any witnesses as well at that hearing?
I don't recall.
So do you remember who made that decision to not allow for witnesses at the hearing?
Did I tell you that there would be no witnesses?
That was in one of your emails regarding the hearing protocols.
Okay, then, yeah, I don't recall whether the attorney advised us of that or we just, I don't recall, to be completely honest.
So did the school board have any influence in the decision to place me on unpaid leave on October 19th?
Did we have any influence? Was that the question?
Yes. Like, did you have any say in that decision?
So generally, with personnel matters, they come to us as recommendations, or here's my, Jody or superintendent would say, here's my intent, or here's what I think would work. And the board, if we disagree, have the opportunity to speak up.
And so at that point in time, you didn't disagree with that decision?
Correct.
That'll be it for this witness.
This is your time to cross. Okay. So we're good on letting this one go. Thank you for your time, Mary Ellen. Appreciate that.
You bet.
Thank you.
Sarah stepped out, but I believe a 5-minute run to the bathroom is necessary at this time. So we're gonna pause the record and we will take a 5-minute break and back here at 2:36. Thank you. We still are on here.
Yes, we are.
Just a heads up.
I take it that we are pretty much that. I'll stop it.
Yes, we'll be. You.
You left, we all left.
All right. Put it on.
Excellent. Okay, and we are back on the record. Just as a reminder that we will be done today at 4. But we have the 14-day window to discuss anything else moving forward. So the district, you guys have your next.
Yes, and I will just have a few questions.
Did you have a question too?
Yeah, I also had a question too. So
Go ahead.
it's kind of logistical. So it's a logistical question.
Excellent.
So is the kind of the goal to be able to, direct examine the district, direct examine Mizu, and then I cross-examine her, and then I do my direct. And then are we going to also have Brenda Moyer today? Is that also happening, or does that need to be rescheduled?
I mean, I guess it's all a question. I don't want to have a witness start and then not, and then we can't finish with that witness. So calling this witness, I will have only a few questions for, and then I expect that you will finish by 4 o'clock with this witness that we're going to call this witness.
Okay.
With Brenda, if there's relevant testimony to be taken, which I don't see, but I don't know which questions you want to ask. We'll have to put her in the 14-day window or whenever we can schedule another day.
So was she not scheduled to be here to testify today?
Well, she's available, I believe, but
She's available today,
yeah,
but after Friday, not.
yeah, but we're not going to get finished with this witness and her both, given the time that you've taken with previous witnesses. So,
Okay, because I was under the impression that the district was going to have all of the district representatives.
having trouble hearing this, sorry.
Oh, I'm sorry. I was under the impression that the district was going to be arranging for the district's representatives to be present. So I was assuming to be able to ask Brenda my questions today as well, but
Well,
that's not possible.
This witness, but I go first with my witnesses, and so I'm going to call this witness.
okay,
I think it pays for us to both do my examination and your examination.
Mhm.
If we have any time left after that, before 4 o'clock, we could probably start, but I don't see any way that, given kind of pace that we've been making, that we would finish with her. So,
Let's just go ahead and get started on this one. And excellent. Hi and welcome. Can you hear us okay? I think you're muted yourself.
muted.
Yeah, I tried to unmute earlier and it wouldn't let me, so sorry. Yes, I can hear you fine. And
Thank you.
yep, if I'm looking up, it's because I have the Zoom on a separate screen so I can look at documents here.
Excellent. Thank you. Can you please state your full name and spell your last name?
Yes, Mizu Burris, Burruss.
And please raise your right hand. Under penalty of perjury, do you solemnly swear or affirm that the evidence you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. I need to remind you that your testimony is being recorded. It is therefore important that you give audible responses that are clear, such as yes and no, rather than slang or just nodding your head.
I will.
Okay, Ms. Hungerford, this is your witness.
Thank you. Ms. Burrows, how long have you been on the school board?
I joined the board in 2013.
Okay. Have you been a resident of Mapleton area or the school district area before that time, where you served on the board?
Yes, I've been a resident of the area since since 1980, I think.
Okay.
But I was gone some of that time as well.
I see. Have you had any children or grandchildren or family members attending Mapleton schools?
Yes, my 3 children have all attended or are attending Mapleton schools.
And did you know Julene Walker prior to the COVID period?
Yes, I've known Julene because my family is grown up here. I grew up here and Julene grew up here. So yes, I knew her prior to the COVID period.
Okay. When school resumed in the fall of 2021, were you informed by the superintendent about requirements as a result of the governor's order that there be vaccination or exemption for all school staff would be required?
Yes, we are kept apprised of changes to the state requirements for schools as far as COVID is concerned regularly. And particularly, we discussed the coming announcement at our board meeting on August 18th, and then on August 19th, received follow-up information detailing what was in that announcement.
Okay. And did the superintendent keep you apprised in that fall of the progress of ensuring that teachers were going to be compliant with those requirements?
We received regular updates about Ms. O'Mara's conversations with teachers in work sessions and meetings and emails. None of those to me contained names, but they didn't include sort of numbers and status of, people who were in each category.
Was there a point in that fall when you became aware or were informed that Ms. Walker was not going to be vaccinated or take an exception?
So I was thinking about this, and I don't believe that I was notified specifically about Ms. Walker not taking the vaccination, but I was that a staff member, yes. And then I don't know whether this is relevant or not, but my children were in Miss Walker's class, so I knew via that because there was an announcement to the class from Ms. Walker that she would no longer be teaching. So, but communication from Ms. O'Mara did notify us about a staff member.
Okay. Then in March, roughly of 2022, do you recall receiving information from the superintendent indicating that she was making the recommendation for the termination of Ms. Walker?
Yes.
Okay.
March 14th.
March 14th. Were you present at the April 20th board meeting when the board heard that recommendation and took action on it?
Yes.
And were you present during the executive session prior to any action in open session?
Yes.
And during that executive session, was Ms. Walker given a chance to respond to the board on an inquiry about whether she would be willing to either be vaccinated or to have it take an exception? That that question was apparently asked. Do you recall that?
Yes, I do recall that. Yes,
And-
that question was asked.
And what do you recall was the response by Ms. Walker?
As I recall, Ms. Walker's response was that she would, I don't know how to phrase it, but be exercising her rights not to do not to get vaccinated or get an exception.
Okay. In open session, then the matter was put to a vote. Did you vote to dismiss?
I did.
And I don't know if you made any comments at the time in the open session about the situation. What was your reason for voting yes?
I voted yes because I understood our responsibility as a school district to not employ any staff member who didn't provide either proof of vaccination or proof of an exception. So to uphold our responsibility under what I understood to be the law and was advised was the law. And so, but I did, yes, you asked, I think the other part of that question was, did I say anything about the way I voted? And I briefly sort of seconded, Michelle Holman made a longer statement about how the difficulty of this decision. And I said that this, I agreed with Michelle because she had said, that I was also having difficulty with the decision. Well, not with the decision, but with the pain the decision was causing or perceived pain potentially to Julene and to myself.
Mm-hmm. And you mentioned just a minute ago that you had been advised about this process. And who are you referring to?
We had throughout the process, Ms. O'Mara reported to us, I think in most communications to us, updating us about the board. She would always include who she had consulted. I guess I shouldn't say all, that's very definitive, but very often in her communications, she would say that she had consulted on various agencies and attorneys, to try and make sure that we were following the law. So in this case, at that hearing, we had Callan Sterling, who was an attorney advising us, calling in for that meeting.
Thank you. That's all the questions I have.
Ms. Walker, would you like to cross?
I don't have anything to cross-examine, so should I just go with
Okay.
direct examination?
Yep, go for it.
Okay. I'm trying to eliminate other questions that have already been asked, so for the sake of time here. So you've mentioned in your previous testimony that you found out through your children that I was no longer being employed by the district. At that time, did you also know that I was, well, I should say, I was no longer being allowed to work? And then at that time, did you also know that I was not being paid?
I think that was the day, I think that was like October 18th. And so I'm not sure that decision had been made at that time. I definitely did not know on that day.
Okay. So
whether you were being paid or not.
I see. Okay. So, but on October 18th, that said I'd be placed on unpaid leave. That's when you knew, basically, when you received that letter.
Yes.
What steps did you take in your role as a school board member to ensure that the prevention of me working and being paid by the district was done lawfully?
As a school board member, I relied on the expertise of other of our outside counsel through Superintendent O'Mara. So I know Superintendent O'Mara reported to us all of the people that she consulted as part of making the decision, and I relied on their expertise.
Are you aware of the laws that govern the dismissal of contract teachers?
I am aware that there are laws that govern the dismissal of contract teachers, and I have done my best to acquaint myself with them, but I am not an expert on those laws.
Did you find that the district's treatment of me since October 19th, 2021 was done lawfully?
I am not able to rule on whether it was done lawfully or not, because I don't, as I said, I'm not an expert on those laws. However, the counsel that we retained to guide us through all of the COVID-19 regulations and decisions made with those in mind indicated that it was lawful, and I did trust that, or put my faith in that.
So did you receive the March 9th 20-day termination notice from Superintendent O'Mara?
Yes, I did.
And did you also receive the attached document entitled Accountability for Schools for the 21st Century Law?
Yes, I did.
Did you read both of those documents in their entirety?
Yes, I did.
This is just for your reference, is Exhibit A3. So on page 6 of Exhibit A3, it talks about 342.875 suspension reinstatement. On October 19th, how would you describe my employment status with the district?
Unpaid, actually on October 19th, let's see, I'm not sure. I would be in between, for the majority of the time period up through the hearing in October and April 20th, I would have categorized it as unpaid leave.
Are you aware of any allowance for for the superintendent to put a contract teacher on unpaid leave? Are you aware of any of the law within this document that you read where it's lawful for a superintendent to put a contract teacher on unpaid leave?
I'm aware that that was one of the lawful recommendations from our council that was consulted on this decision.
Okay. So you're not relying on what the Oregon statutes say in that document, you're relying on what the council advised you to do.
Because the Oregon statute that is referenced and others were not necessarily drafted with COVID situation in mind. And I know that there were some, new rules and regulations made around COVID that aren't contained in documents that existed prior to COVID.
So would you say that the OHA administrative rule 333019, the one about the vaccine requirement exemptions, would you say that that ruling supersedes Oregon statute or the laws, for example, that are in this particular document here?
I personally would not say yes or no on that because I did not feel sufficiently legally smart to do that. And so I asked council and council said that yes, that I said yes, essentially, I guess these supersede other pertinent rules.
So basically, it wouldn't really matter what these statutes say. If in your situation, you were just going to go with what the legal counsel said because of their experience in the area of law.
Yes.
So now I'm going to move on to what's in the 20-day termination notice. And I have some questions regarding that. Okay, so there are multiple charges that Superintendent O'Mara alleged that I did. So the first one is insubordination. Did you find that I was guilty of insubordination?
My understanding is that the charges that were communicated in this letter were the legal terms that were applied to the case or were applied in the situation that spoke to the fact that the district wasn't able to ascertain vaccination or an exception. And so I believe that these are the legal terms that were applied to that. And I did vote to terminate based on these claims.
So you said these were legal terms provided. So who are you saying provided these legal terms?
When in I do not necessarily know this was a document that Superintendent O'Mara put together. So that is a question for Superintendent O'Mara. However, I did ask council in executive session about the language, and it was indicated that these were the legal terms, which is the basis for termination. And they were pertinent to only to the vaccination or exception status.
So, so I'm gonna ask you like a few questions about each of those charges against me, and so you're free to answer however you want, but just kind of be prepared that there's going to be about 3 questions per each of those charges. It's not designed to trip you up or anything. It's just I need to, because in my role, I have to determine whether you found evidence for these things. So did you find that I was guilty of insubordination?
I found that the district was unable to determine your vaccination status or your exception status, and that is a requirement or a rule of employment. And so I guess that this is a question that I don't feel comfortable answering. If that determines, if that is legally ruled insubordination, I suspect that this is being argued by a lot of attorneys right now all over the country. And I don't think I'm going to be able to answer that question.
Okay, so you stated earlier that you did vote to terminate my contract with the district, correct?
Correct.
And these were the grounds that were given to substantiate your decision to terminate my contract.
Correct.
So, so I need to know if you did actually find that all of these allegations were true.
Yes, so I can say that as they were intended to relate to the vaccination status or status of exception, then I did find them to be true.
And so what facts, so the top 2 charges, insubordination and neglect of duty, the Oregon statutes require that the evidence to substantiate those charges have to come from evidence from my personnel file. So what facts from my personnel file did you find to substantiate the claim of insubordination?
And again, I'm going to object to the legality of the statement that you've just made to this witness.
Okay, would you like to make a correction?
Yeah, I think that the grounds have to be in some fashion addressed, but typically dismissal documents do not go into a personnel file until after an actual dismissal has happened.
So are you suggesting there doesn't need to be evidence to support a charge of insubordination?
Yeah.
What's that?
It's carried in a working file until there's action by the board. So if you're addressing this and saying a personnel file, a particular file, there are multiple files that the district maintains. Until such action is taken by the board, a document would not be in your personnel file.
So there is an entire section in the Oregon statutes that governs the appropriate maintenance of a personnel file. So you're saying that we're
And
going to disregard that?
we're going to sustain the objection and go to the next question. That can be debated at another time. It's not for right now.
Okay.
Next question, please.
I guess I'm still, if I may ask the panel, so the law requires that to be able to like substantiate the claim of insubordination, it says there has to prove it with evidence from the personnel file, correct?
No.
That it doesn't say that?
Charges have to be related to something that's in the personnel file, but personnel file has a multitude of stages, because it would be inappropriate to place something in a personnel file if the board, let's say, turned down a recommendation for dismissal. So it would be in a working file until such time as the board acted on it.
So it seems like there should be prior documentation for insubordination.
So, and if I may help in terms of legal guidance, to the extent the witness knows, the witness can say, I know, or I don't know.
Uh-huh.
And I've seen like the prior witness struggle with, she felt reluctant at one point to say, I don't know, but this witness and other witnesses, I think if they don't know, they should simply say, I don't know. If they don't understand, they don't understand. To the extent that's the truth.
Yeah.
I don't know if she knows or doesn't know in this, but that's where I encourage the line of questioning, just simply based on what witnesses know or don't know. If they don't know the answer, I would move on.
Yeah. And I was going to allow her to say, I don't know. It's just I was objected to. So I was trying to address the objection.
Okay.
So where are we
I'm
at?
trying to guide us back on path.
Yep, we're ready for your next question.
Okay.
Okay.
So to whom did you find that I was insubordinate?
The district was required to move to obtain to employ people who were vaccinated or had an exception. And you, to my knowledge, didn't provide information that you met either of those criteria. And so therefore, I don't know whether that, I guess, to use those words, I don't know. I don't know whether that constitutes insubordination or not. And I don't because I don't know whether it constitutes insubordination, I don't know whether it constitutes
So you froze for a second there. Could you just repeat like the last sentence of what you said?
Yeah, I will, but I will. And so I don't know. I guess I should just say I don't know, really. Now, I want to reiterate that all of these categories are ones that we were advised could be legal grounds for termination. So in a way, my answer to each of these is going to be yes, because I took our legal counsel's guidance that these were. Now, none of them says who you would be insubordinate to or any of those things. And I believe that those are legal questions that I'm not qualified to answer.
So you're saying that the question of whether an employee is insubordinate to an employer is something that would require legal counsel to determine?
I'm saying that it did require legal counsel, and we did have legal counsel, and the terminology was recommended to us from that legal counsel.
So would it be safe to say that for insubordination, neglect of duty, any cause which constitutes grounds for the revocation of such contract teacher's teaching license, and gross neglect of duty and gross unfitness? So you found all of those to be true, but you didn't have any specific facts outside of the vaccination requirement and exemption requirement. you didn't find any other facts outside of that to justify those charges, to substantiate those charges.
Well, I believe the communication from the district about workplace requirements and the updates from Ms. O'Mara throughout the fall and spring of 2021, 2022. I believe those would count as facts in support.
Okay. And when did you receive those facts?
It's on the timeline submitted as exhibits.
Okay. Are you aware that there are inaccuracies with that timeline?
I'm not aware that there are inaccuracies of that timeline.
Do you believe that the amount of evidence that you had in those communications given to you from, who did you get that information from?
Ms. O'Mara and regular updates, and and then during school board meetings.
Okay. So do you feel that the amount of evidence that you got from Mrs. O'Mara during those emails and throughout the year was sufficient to be able to was a sufficient amount of facts to justify these claims? Insubordination, neglect of duty.
Yes, I feel like that in respect to the way these claims were used to address the vaccination and exception rule.
Are you aware of any, there's the Teacher Standards and Practices Commission that, makes the rules that govern the behavior of teachers. They have a section on the competent educator and the ethical educator. To your knowledge, did I violate any of the TSPC rules outlined? And just for your reference, that would be Exhibit A24.
Right.
Yeah, because some of the charges against me would say that I'm violating a TSPC rule. So I'm trying to distinguish which of the TSPC rules you found that I violated.
I did not specifically find. I think that the termination letter I believe it says that you may have violated those. And I'm not positive. I can go back and look at that. But and the reason I think that is reasonable is because those were not written with the, knowledge about the rules that would be made in response to COVID. Let's see, it does say in the termination letter, TSPC may find that your refusal to follow the law and follow workplace directive.
So, and what you were saying there, so are you saying that the vaccine mandate supersedes the rules that govern the contracts of contract teachers?
That is how we were advised by legal counsel. And that was my understanding of that. Yes.
Okay. On the second page of the 20-page, or the 20-page, the 20-day termination notice, there's a paragraph that talks about an Oregon state law. Do you agree that I violated an Oregon state law?
I believe that it is an Oregon, it's an Oregon regulation. I did have this pulled up so I could refer to it. It's an Oregon regulation. And I am not sure whether you would have violated that, but I believe that if we had continued to employ you without vaccination knowledge, we would have been violating that.
And what would have been the consequence if the district had violated that ruling?
I don't know what they would ultimately have been because we did not take that action. So I don't know what it ultimately would have been.
So in the OAR 333-019-1020, it does, in I think section 11, state that there would be a $500 fine per day per violation if the district had employed employed someone who didn't show proof of vaccination exemption. Does that sound familiar to you?
That does sound familiar to me. Yes.
So, and to your knowledge, did the district have to pay any $500 fines per day regarding my employment?
No. To my knowledge, no.
So getting back to the 20-day termination notice, I'm going to read this paragraph to you and ask you some questions about it. So it's the paragraph on page 2 that starts with Oregon state law. It says, Oregon state law requires teachers to, the bracket starts, get vaccinated / wear a mask / have an accepted exemption. The refusal to bracket get vaccinated / wear a mask / have an accepted exemption renders you unqualified to perform your professional responsibilities of a teacher because the school cannot lawfully employ you unless you get vaccinated / wear a mask, have an accepted exemption. Such conduct may constitute gross unfitness and because for revocation of your teaching license. To your knowledge, did I ever refuse to wear a mask? To your knowledge?
Not to my knowledge, did not refuse to wear a mask.
So since this was an allegation by Superintendent O'Mara that I had done, since you had not found that to be true, did you follow up with that and ask why that was included in this letter that I was being accused of not wearing a mask?
I'm not sure what, so I think my understanding of the brackets is different than your interpretation of it. And so I understood that it was that was denoting possible actions that would then say, render you unqualified to perform professional responsibilities. And that it was any of those things, not all of those things. But that was an assumption on my part, and I did not double check that assumption.
So if it's possible that an assortment of things could be provided in this case, is it possible that an assortment of other charges, the other 5 charges, could also be untrue as well?
I think I need you to clarify that question. I don't understand.
So my question is, so here we're given 3 different options to choose from. So get vaccinated, wear a mask, have an exception. So I'm given choices to choose from. So what that's telling me is if I'm given choices in that regard, perhaps I'm getting choices of things to choose from in the other accusations as well. So I think it's relevant because, if you're not following up to see if that was a true statement, when did you follow up with the other statements as well to see if those accusations were true as well?
Well, I don't see brackets in any of the other ones that have that, have that same indication. And so but the part I didn't follow up on was my assumption that those brackets indicated any one of those things, but not necessarily all of them.
Okay. So, so you're just saying specifically in that instance, with the brackets and the slashes, it was kind of like, A, B, or C, choose one of the options.
That was my understanding. Yes.
Okay. I'm going to look through my questions and see if there's something else I'd like to ask you. So you can take a breather for a second. And I will too. So, how did you know that this spring I was or was not vaccinated? How did you know my vaccination status this spring?
I think the onus was on the district to obtain vaccination status, declaration of vaccination status one way or the other. And if we didn't obtain that, I think that I would, and again, I guess this is outside of my legal depth, but not even legally, I would say that without proof that there was, that we have to assume that there isn't. So I'm not sure that answers your question. But we never proof that you either were vaccinated or had an exception.
So, did you receive the March 15th email? It was 4 pages that I outlined the grievances that I had against the district.
Yes.
And you read it in its entirety?
Yes.
Did you also read the full defense document that was 28 pages with 31 exhibits outlining my grievances towards the district, as well as my defense against the termination to recommend my dismissal? Did you read all of that in its entirety as well?
I did read all of that in its entirety, except for the entirety of exhibits T through Z, which were constitutional and Nuremberg laws. Specifically, I did skim those, but I did not read those word for word, but I did read all of the rest of it word for word.
Are you aware in that document, the 28-page document, that I was asserting my rights under the Americans with Disability Act, which would be under Exhibit A21 in our current exhibit list, and ORS 659A.136 and the Nuremberg Code, and therefore I did not reveal to the superintendent or to the school board whether I had or had not been vaccinated at that point? Were you aware that I was asserting my right?
Yes, that was understanding.
Okay. This is similar to my question regarding knowing my vaccination status. Another allegation within the document said that I did not have an accepted exemption. Do you did you find that that was true, that I did not complete a exemption for the vaccine?
As far as I know, we have no record of that. That obviously doesn't mean you didn't do it. We have no record of it, as far as I know. The district doesn't.
And would you find, or did you find that not having that exemption was a gross neglect of duty in any way?
I found that it was grounds for not being able to continue employment. And then the gross neglect of duty term was a term for that, the legal term for that. One of the legal terms for that.
So I signed a contract with the district on June 15th, 2021. To your knowledge, was the requirement to show proof of vaccination or complete a religious exception, was that a condition of employment at the time of me signing that contract on June 15th? Do you know?
I don't believe it was a condition of anyone's employment because I don't believe the mandate went into place until August 2021.
So would you say that the enforcement of the vaccine mandate is a new condition of employment added on top of the contract that I signed on June 15th, 2021?
I feel like that terminology there might be some legal distinctions in that. I do believe that the vaccine mandate and being either vaccinated or having an exception is required for employment in the district.
So it's an additional requirement on top of the contract requirements.
No reason to object to that language, sure, but I might be misspeaking legally. I'm not sure because it wasn't related to the contract requirements. It's a separate requirement.
Well, it is related because that's what you're saying. It was the reason for my contract ending. So I think it's relevant.
Are you referring to
I'm
the
saying it's relevant. I just don't.
employment contract?
What's that?
Are you referring to the individual employment contract as opposed to the collective bargaining agreement?
No, I'm referring to my individual contract that I signed on June 15th and that Jody O'Mara also signed. So that's what I'm referring to.
Okay, that
Yeah.
clarifies.
Yeah. So regardless of whether it's now a new condition of employment or not, do you foresee that being written into future contracts for the district? Do you feel like the district's probably going to work that into new as a duty for district staff in the future?
If it remains a requirement from from the state for the district, then we would, I imagine, consult legal counsel when drawing up new contracts. And if they suggested that it be included, then I believe we would include it.
How do school district boards determine what is contained within the contracts? What's the criteria that they use to determine what's in the contracts?
Again, you're talking about the individual employment contract.
Yes.
I don't feel, I guess, we go through not the collective bargaining agreement.
So you follow the collective bargaining agreement. So would you be following the collective bargaining agreement with my contract? Like in order to, make decisions about my employment, would you follow the collective bargaining agreement to do that?
I don't really, I'm afraid that this isn't something, I think I should use those words. I don't know here. We would follow all agreements in good faith that we had made, and we would research any new proposed changes, and those changes would be included with the opportunity for the employee to read them and review them and sign or not sign the contracts. So beyond that, I don't know how to answer the question you're asking.
Since the vaccine mandate wasn't a condition of employment at the time that I signed my contract, what do you think should be done with that contract at this point?
So I did not prepare for contract specific questions like this because the hearing I thought was limited to the termination hearing and the steps leading up to that. So I'm going to have a lot of I don't know questions. I do think that there is that there's an avenue for that, and I would, but I don't know about that. I do think that this is unfortunately in the state probably a huge question in all districts right now about contracts and how they relate to these new rules and how these new rules relate to them, and how they should be either worked in or not worked into future contracts. But I don't have answers to those questions yet.
I'm going to see if I have any other questions for you. 1 second, or maybe a few seconds. So referring back to the 20-day termination notice, which is required by Oregon law to provide a plain and concise statement of facts. Do you feel that this document here, my 20-day termination notice, would fulfill that? Is a plain, concise statement of the facts when it doesn't even cite the law that I'm alleged to have violated? Like this, it says I violated a law in here, but it doesn't actually cite the law that I violated. So
And I think that's a legal question that the panel ultimately has to answer, whether this board member feels that it does or doesn't. I don't believe is really probative evidence here.
okay, I'm just, if I violated a law, I feel like it should be cited in the documents.
That may be your feeling, but again, it's a legal question,
Okay.
not one that this witness can answer.
So the requirement, so you said that you based your decision to terminate me on the requirement to show proof of vaccination or have the religious or medical exception, correct?
Correct.
So where did that requirement come from?
So let's see, I have a lot of tabs open. So like there are a lot of rulings on it. My understanding, and I just pulled up one statement that that supports that, was that, or that I actually was guided by, in my understanding of this, both as a school board employee and as a a person who was acting as an employer in my own work life. Says it makes it clear that employers may require workers to receive a COVID-19 vaccine with limited exceptions. This is also true under Oregon law. And then, let's see here. Trying to find the actual statement, which was referenced, and I have so many tabs open that I'm not able to flip through them efficiently. Okay. This was referenced in the 20-day termination. It's OAR 333-019-1030, which requires in section 3 that after October 18th, 2021, teachers, school staff, and volunteers may not teach, work, learn, study, assist, observe, or volunteer at a school unless they are fully vaccinated or have provided documentation of a medical or religious exception, and the exception has been approved or accepted. Or B, a school may not employ, contract with, or accept the volunteer services of teachers, school staff, or volunteers who are teaching, working, learning, studying, assisting, observing, or volunteering at a school unless the teachers or school staff are fully vaccinated against COVID-19 or have an approved or accepted medical or religious exception. So that's the rule I was operating under.
Okay. So which document were you reading, if you don't mind me asking?
Sure. I was reading an excerpt from the district statement on termination exhibit D22.
Okay, so you're referring, it's outlined in the presentation, so this is the ruling that you use to make your decision, not, it wasn't what was provided in this document.
No. You asked, I think you can repeat your original question. Maybe I didn't address it. My understanding was you asked what law or rule did I have in mind? And so you can, if you want to restate your question, I might have taken it the wrong way.
No, that would be correct. So I wanted to know what the authority was that you were referring to for me to show proof of vaccination or fill out an exemption. So
OAR 333-019-1030.
okay. And to your knowledge, is that a ruling or is that a law?
An administrative order it's the technical term that, yeah. Permanent administrative order.
Do you have any more questions?
I'm just checking real quick.
Okay.
Making sure. So, what criteria does the district board use to determine whether or not it will adopt an Oregon administrative rule from a government agency as part of the duties for contract teachers? So is there a criteria that the board uses in order to determine if like OARs are going to be required as duties for teachers or staff at the district?
Yeah. Usually, so there are a lot of changes to OARs regularly and OSBA regularly provides, they provide suggestions in the form of OARs that have some options, and that those are, suggestions and options that have been legally vetted and concerned. And so our process is to take now and with the now to in conjunction with the suggested changes and
Excuse me. Sorry, you were kind of breaking up there. Your explanation is great, but I just missed like 3 or 4 sentences of it. Could you go back? I have,
try.
The OSBA provides suggestions and options that are legally vetted.
Mm-hmm. And then we review those, we look at what our current policy is and we look at the changes and we determine that if there are changes that we, want to adopt. We usually adopt the changes that are recommended to us because they're usually in response to changes in the law. And then, and occasionally we will look at something and ask for clarification and go and get clarification from parties who have expertise on the matter. And then we will adopt. So we do a first reading where we read it, then we do a second reading, and after the second reading, we either adopt or ask for more. We ask for more clarification.
Are Are all contract teachers for the district now obligated to disclose private medical information to the district in order to be employed by the district?
I'm going to object in terms of the characterization about releasing private medical information. What requirement is to fill out one of the two forms, either to say that you've gotten a vaccination or you will accept, you're asking for exception.
Can I ask the witness if she thinks that sharing vaccination status?
So just define it as this, one of the two, the COVID-19 mandate,
Okay,
not all medical.
okay. So are all contract teachers for the district now obligated to disclose their vaccination status information to the district in order to be employed by the district?
It's my understanding that we are legally required to have, yes, to have a record of either vaccination or exception or approved exception in order to employ staff.
And since this is an Oregon administrative ruling that was developed by the Oregon Health Authority, has the district transferred any of its authority over contract teachers to the Oregon Health Authority, to your knowledge?
Not to my knowledge.
But you are saying, though, that their ruling is being enforced by the school district and therefore is determining whether a contract teacher can be employed or not by the district, correct?
Yes, correct. Actually, I'm not sure that OHA, it's a permanent administrative order. I don't know if that is, if OHA makes the order or if OHA advises for the order to be made and then that is made. So I on that point, I'm not sure, but we did accept the directive. We did accept OAR 333-019-1030 as an administrative order that we were going to operate under.
To your knowledge, did the district incur any fines? Forgive me. I think I did. Did I ask you? I asked, yes, never mind. I did, sorry. Okay, I just want to make sure.
So it's a long day and lots of, you have to ask everybody the same questions, I assume, so.
Yes. So to your knowledge, does PACE provide the district, not yours, but the district's liability insurance related to lawsuits and things related to the district?
Yes.
Did they make any assurances to the district that they would defend the district if anyone filed or charged the district with any, I guess, if they made a claim against the district that the district was responsible for the adverse reaction or adverse reaction to receiving the vaccination that they were required to get?
And again, I objected to this question earlier. I think the question that's relevant here is whether PACE indicated that they would defend the district if the district did not follow this rule. Employment.
We're gonna sustain it again because it was the same objection last time.
Okay. And I think that's it.
Do you have any? Okay. think at this point, thank you for your time.
Thank you.
Thank you.
Good day.
Okay, moving forward, I don't believe we have time for another one today as we are wrapping up our time here. Do you have any advice on moving forward?
So the letter that was sent out, clarification on the hearings process, basically created a 14-day window for if witnesses, because we did not know where we would land with witnesses. We had differing positions on the appellant. But it was a 14-day window to basically schedule this testimony. To the extent it wasn't clear, the last sentence of that letter was it may be extended beyond the 14 days as necessary for parties. I don't know how much more testimony is needed from the district side or the appellant side. You both know how much more is needed.
Well, I elected not to call the high school principal, and I have called all of my witnesses.
Okay,
Yes.
would it be accurate to say the district rests or?
I think that it would be accurate to say that the district rests in terms of protecting direct examination. Obviously, we have the right to cross-examine the witnesses that would then have to be called if they choose to call the high school principal. And then if they chose to call for their own direct examination, the superintendent. And then there, of course, is the testimony of the appellant.
Okay. Is that accurate to say that's what else would be needed for the appellant's case?
So I have quite a few actually, questions for Superintendent O'Mara, well, retired Superintendent O'Mara. As I stated, she's gonna have most of the questions because I was working most directly with her. My direct examination of her would be pretty substantial. I think it would, like I said, it could take 3 to 4 hours going through each of the questions that I have for her. And hopefully by that time though, if we postpone it, I can weed it down a little bit and try to things that we've already done, I could possibly trim it down. With Principal Brenda Moyer, this isn't going to take very long, maybe 20 minutes potentially for her. And then since this is taking a while, I may not, after having done my direct examination of those two witnesses, need to, examine myself. So, you know what I mean? Everything that I need to bring out forth could already be done in those two witnesses. But I do definitely think I would need at least one more day to, not the entirety of the day, but at least part of that day to might know.
Here's the other question to ask the parties is, do we want to cooperate, find a mutually convenient time? That would be helpful.
Mhm.
I assume if everyone's by video, it would be easier to have it done sooner. If everyone has to assemble in person, or at least some of us, it's probably take longer to schedule. So what's the party's comfort levels with that?
If we're going to make a decision on the format, because I really feel like this was difficult for the witnesses to figure it out and manage it on the computer. I don't think that's going to be resolved at all by all of us doing that. And I don't think it's going to make things go more efficiently. In fact, it could make things go less efficiently. So I lean towards having it in person again. But if I could reserve my choice to make it one way or the other, if I could think about it for a couple of days, my brain's a little more fresh, and maybe we could do that by email, I would consider it another option, but I just don't want to commit to it right now.
It just affects, I think, timing and availability. People have to, panel members have to travel, others have to travel.
Yeah.
And it's just a time issue.
Yeah.
Okay.
I can't see that we could reschedule within 14 days if we have to do it in person. Just because the knowledge of where superintendent is going to be and my availability is going to be a lot greater if we do it remotely, I think.
Nancy, I can't really hear you.
Nancy?
Oh, sorry. Yeah.
Thank you very much.
I was just saying that I think my availability is going to be greater if we do it remotely, or at least let's just see what dates we could come up with. I think we should try to look for dates now. It's a lot easier to do it when everybody's in the room as opposed to having to do round robins of,
Going to do anything with the record while we work through this, or do we want to leave it open?
Since we're discussing dates, we can certainly. But we can probably close the record. I
Yeah.
think.
We're gonna, okay.
Yeah, I think is that.
So we'll go ahead and close the record. And we will resume at a later date
For the second.
for the second. Okay, so yes, I think we're good. Thank you.